Pero the matter will be listed day after tomorrow. Day after tomorrow, this matter will be listed with other matters. One IA has been filed for withdrawal of 50% deposited by the insurance company. I am for the claimants.
When do we list it?
On 14th.
Pardon?
14th
14.
of license.
May I please, Lordship? I pray for listing a matter which was last posting was in the month of February, Lordship.
When do we want?
In admission column, Lordship.
On
When?
21st, on 21st August.
Obviously.
May it please your lordship. Lordship, I beg to mention item number 31 with the consent from the petitioners, my lord. My lord will file a reply. Lordship may fix it after 2 to 3 weeks as per lordship's convenience. I have
31.
consent, my lord. Yes, my lord.
Did you inform the other side?
Lordship, I've taken consent from them, my lord.
But I am here.
Mr. D.K. Badaya, learned counsel for the respondent number 123
my lord.
with consent from the other side, press for listing the matter after
2 to 3 weeks as per lordship's
after
convenience.
after 3 weeks. After 3 weeks, so as to enable him to file
Reply, my lord.
reply to the affidavit.
Reply to
No,
the
reply to the
my lord, reply to the contempt petition, my lord.
reply to the contempt petition. Okay.
Deeply obliged, my lord.
May please, your lordship. And I beg to mention item number 32, my lord. Lord, in this case, I have filed
Item number 30,
32, my lord.
32.
I have filed affidavit in opposition today, my lord. The matter may be fixed after 2 weeks. I have informed the other party, my lord.
Mr. A.K. Azad,
My lord.
learned counsel for the respondent number 227 with consent from the other side, press for listing the matter after
2 weeks.
2 weeks.
May I please, your
Okay,
lordship?
Arula.
Lord, with the consent of the other side, I beg to mention item number 27. Madam. I pray for 10 days time in this case. Madam. I am for the petitioner.
With consent from the other side, Mr. S.K. Chakraborty, learned counsel for the petitioner, press for listing the matter after
10 days. Madam.
after 10 days. Fair allowed.
Deeply.
May it please your lordship, I beg to bring for listing CRP lordship
When?
as per his convenient of his court.
On 22nd August.
Deeply obliged.
May I please, Lordship? Lordship, I beg to mention item number 19, Lordship.
19.
We have taken the consent of the other side also. And for the respondent. In this matter, Lordship, we will file our affidavit in opposition by tomorrow. Thank you.
You are for respondent or petitioner?
Respondent, Lordship.
Respondent number?
There is only one respondent, Lordship. So
One. Your good name?
W. Rahman. On behalf of Mr. K. Kalita.
Okay.
Kalita.
Mr. Rahman, learned counsel appearing on behalf of Mr. K. Kolita, learned counsel for the respondent number 1. With consent from the other side,
I'm
press for
protecting.
listing the matter.
I'm for the affidavit.
Okay.
J.
Uh,
Das. J. Das.
J. Das for appellant. Press for listing the matter when?
6th of September.
6. Okay. Fair enough.
May I please, lordship? Here for listing lordship in RIC matter lordship.
When?
Lordship 2020.
May I please your lordship, I beg to mention for listing of an RFA on any day in this week.
Next week.
This week,
COVID.
21st.
any,
21st August.
if possible this week,
On 16th.
on 16th.
16th.
My lord, item number 5, this is an contempt petition against the judgment of MSC appeal. My lord. I may be allowed to withdraw.
Allow to?
Withdraw.
Your good name?
And Sharma.
Mr. N. Sharma, learned counsel for the petitioner, submits that he has the instruction to withdraw this petition. Here is accordingly allowed. This contempt case number 409 of 2024 stands disposed of on withdrawal.
May I please, your lordship? In item number 2, I have filed an affidavit in opposition, additional affidavit that may be called on record.
Okay. Kavi.
May it please your lordship, I beg to mention RFA 36/2017. Lordship, as per the previous order dated 4 June 2023, the matter was supposed to be listed.
When do you want?
Lordship, 23rd August.
23rd August.
23rd August is holiday. On 27th.
27th August, Lord.
Okay.
Lordship, I also beg to mention miscellaneous first appellates of 2019 matter and matter has not been put up in last 4 years.
On 29th. 29th August.
Much obliged, Lordship.
May please, your lordship. I'd like to mention a revision petition, my lord, for listing, my lord. The very old case of 2014, my lord.
When?
Any date, my lord.
COVID?
27th.
I beg to mention item 45.
Pardon?
45 of daily list.
Pardon?
Beg to mention 45, item number 45. Here I am for the petitioner. my lord. I have verified the record. Service is yet to be completed.
So when do you want?
After 2 weeks,
Your good name?
S. Chauhan.
Mr. S. Sohan, learned counsel for the petitioner, pays for listing the matter after 2 weeks. There is accordingly allowed.
My lord, another item, item 34, my lord. Here, my lord, I am for the respondent. Here, I am supposed to file objection, my lord, against condemnation of delay, my lord. After 2 weeks,
Did you inform the
I
others?
have taken consent.
But your name is not there,
No, I am appearing on behalf of Mr. B. Pusilal.
Mr.
B. Pusilal.
Mr. So-and-so, learned counsel appearing on behalf of Mr. B. Pusilal, learned counsel for the respondent. With consent from the other side, press for listing the matter after
3 weeks.
3 weeks. They are allowed.
My lord.
My lord, with consent of the respondent, I beg to mention item number 6, my lord. The matter may be come up on 3rd of September, my lord. If lordship please. Item number 6, my lord.
Your good name?
DK Das, my lord.
Mr. D.K. does with consent from the other side, press for listing the matter after
On the 3rd of September, my lord.
3rd of September. Why 3rd of September?
Because my senior is available on that date, my lord. If your lordship please
Who
another,
is your senior?
Mr. R.K. Bhunya, my lord.
Okay.
I am for the respondent.
Any objection?
I have no objection.
Okay.
Hello, my lord.
Obliged.
Your good name, please?
B. Hazarika.
B. Hazarika.
May I keep the lordship? Lordship, I beg to mention for listing lordship. Matter
When?
pertains to make appeal. Next week, lordship.
Next week. Take a date from him.
On 21st August.
Lordship, there is a 2 matter, lordship.
2 matters. Then one on 21st, one on 27th.
May I please, your lordship? I would like to mention for listing of one review petition, your lordship.
When?
On 20th of August,
Review petition. Against order or judgment
judgment
passed by
passed by H. Sarma.
H. Sharma. Okay. Take a date from him.
On 20th.
May we please, your lordship? I beg to mention item number 10, your lordship. My senior PS data is out of station, your lordship.
Item number 10.
10. I've got.
You are for the? You are for the
Petitioner, your lord.
petitioner?
I'm for the respondent number 125.
125. Miss, your good name?
J. Das.
M for me. M for me.
Learned counsel appearing on behalf of
PS Deka.
P.S. Dekar, learned counsel for the petitioner. With consent from the other side, press for listing the matter after
On 6th of September. 6th of September. 6 September.
6 September. Okay.
6 September, bigger case of it.
6 September. 6 September.
Okay.
Highly obliged.
May I please your lordship? Lordship, I beg to mention for listing of an item. It's a regular second appeal, 81 of 2022. It was to be listed on June 2023, but it has not yet been listed, my lord.
When do you want?
16th of August, if possible.
16.
16.
16 may not be possible.
If not possible,
Okay, one case.
One case.
Okay.
Okay.
obliged.
Items from daily list for motion bail application. Item number 1.
May I please your lordship? Say application under section 483 of the NRS. Lordship, in this case, petitioner is arrested on 16/11/6/2024. Lordship, get the FIR at phase 15 million.
Page number
15, 15
15.
million is translated to million. Lordship, FIR was lost against 2%, petitioner not named, but during investigation, million, she was arrested. And it's appeared that she was arrested for the offense under section 313 of IPC. And co-accused has been, was arrested and lordship has granted bail in lawsuit, find out order at 28 million.
co-accused.
Lordship.
When?
28 million. That was that order dated 29/1/2022. It was lordship under section due to not submission of CDB Sergeant Miller. Default bail.
Okay, the case is registered under POXO Act.
Lordship.
So at this is notice will go.
Lordship.
And you produce the case diary along with this search sheet is submitted.
That was not mine.
Gotcha. Then search sheet along with a statement of the victim guard.
Whether search sheet submitted or not, whether search sheet submitted or not.
If submitted.
Fine.
Heard Mr. M. Monto, learned counsel for the accused, and Mr. B. Sarma, learned additional PP for the state respondent. This application under section 483 of the Bharatiya Nagorik Suraksha Sanhita BNSS 2023 is preferred by accused. Srimati Puli Mili alias Sobita Sukrang Mili, who was arrested
On 11/6/2024.
on 11/6/2024 in connection with Bipuria PS case number 184 of 2023, registered under section 376(3), 313, IPC, rated section 6 of the POXO Act. Where is the petition and the documents placed on record? Let notice be issued to the respondent. Respondent number 2. Through the learned PP, Assam, within 2 working days from today. The learned additional PP shall produce the case diary before, along with the statement of the victim girl and the medical report of the victim girl before this court on 22nd. And also, after causing service of notice upon the respondent number 2, the learned additional PP shall produce a report from the jurisdictional PS. List on
22nd. Item number 2.
High level.
The additional affidavit is called for, matter may be taken up after some time.
Okay.
Item 3.
May please.
Yes.
This revision is against an order whereby my amendment application has been rejected. Now, what's happened, my lord, here, the petitioner, my lord, was a plaintiff. My lord. As a plaintiff, my lord, he filed a suit for recovery of possession over 6 bigha, 1 katha and 12 lesas of land against defend number 1, 2 and 3. During the pendency of the suit, my lord, the defend number 1, there was a compromise between the defend number 1 and the plaintiff. And in respect of 1 bigha, 3 katha and 4 lechas of land. Now, my lord, the amendment which has been sought for is for deduction of this measurement of land against which there has been a compromise decree with the defend number 1. Because the suit was for 6 bigha, 1 katha and 12 lechas. Now, in respect of 1 bigha, 3 katha, 4 lechas, there has been a compromise between the defend number 1 and there is a compromise decree already executed. So the measurement of land has to be deducted. This land will go out of the suit land now. That is the only amendment which we have. If your lordship finds,
Why it was rejected?
but it was said that earlier we filed an amendment application, it was allowed, and we did not take this amendment at that point of time, and therefore there was no due diligence. And now the issue has been framed and it is fixed for plaintiff evidence. Now the ground which has been taken in the amendment application was, while preparing the evidence, my lord, it came to the notice of the plaintiff counsel, my lord, that the schedule has to be modified because in view of the compromise that has happened earlier.
Hmm.
If your lordship finds the schedule of the plaintiff at page 19, my lord, you can see. Page 20 is the schedule B. My lord finds here the measurement of land is 6 bigha, 1 katha, 12 lesas of land.
Hmm.
Now, my lord will kindly find page 21 is the petition that was filed by defendant number 1 and the plaintiff, my lord, joint petition for compromise.
Hmm.
Para 4, your lordship will find. Defendant number 1 was occupying 1 bigha, 3 katha, 4 lesas of land
Hmm.
out of this schedule B. And your lordship will find the para 9, my lord, page 20, page 22.
Hmm.
Petitioner number 3, defendant number has paid the value of 1 bigha land and surrendered, handed over remaining 3 katha, 4 lechas of land. So to this, in respect of 1 bigha, 3 katha and 4 lecha, the compromise decree was done at page 23. my lord.
Hmm.
Now
Yes.
the amendment which I have sought for, my lord will find the page 36 is the amendment application. Page 36.
Hmm.
The proposed amendment at page 37, para 5. That at the time of preparing of evidence of the plaintiff witness, it comes to the knowledge of the plaintiff that the schedule of the plaintiff is required to be amended as under a plot of land measuring 4 bigha, 3 katha, 8 lechas covered by periodic patta number so and so, dag number so and so, of so and so, so and so. Now this 1 bigha, 3 katha, 4 lecha has been deducted from the original measurement. That's the only amendment. The impugn order your lordship will find from page 41.
Which is the operative portion?
My lord, page 43, para 5 only. My lord finds page 43,
Yes.
para 5. May I read it?
Yes.
Peruse the case record. Upon perusal of the same, it is crystal clear that the compromise with the defendant number 1 had taken place on 23/7/2018, subsequent to which the compromise decree was also drawn up accordingly. It appears that the subsequent to the said compromise with defendant number 1, numerous petitions praying for amendment of the plaintiff were filed by the plaintiff side which were allowed. The petition under Order 6, Rule 17 was filed by the plaintiff side on the date of compromise itself, but did not contain the prayer for allowing them to make the said amendment in the schedule, as has been prayed by instant petition. Moreover, even subsequent to the compromise with defendant number 1, numerous prayers for amendment of the plaintiff were filed by the plaintiff side on various dates on so and so, so and so. But none of the said prayers included the amendment of the schedule and the boundary as prayed for instant petition. Now, after a lapse of almost 6 years from the date of compromise of the plaintiff with the defendant number 1, the plaintiff had on 13/2/2024 filed the instant petition under Order 6, Rule 17, praying for amendment of the schedule and boundary of the suit land on the ground that the schedule has changed after the compromise of the portion of the suit land and with the defendant number 1, which had taken place in 2018. In the instance suit, the issues have already been framed and the case is pending at the stage of submission of evidence of affidavit by the plaintiff witness. Considering the stage that the issues in the instant suit have already been framed, I am of the opinion that the circumstances of the suit need to be examined keeping in perspective of the proviso to Order 6, Rule 70. Proviso of the said order postulates that no application for amendment shall be allowed after the trial has commenced, unless the court comes to a conclusion that in spite of due diligence, the party could have raised the matter before the commencement of the trial. In this context, the learned counsel for the plaintiff side had submitted that at the time of preparing the evidence of the plaintiff witness, it came to the knowledge of the plaintiff that the schedule of the plaintiff is required to be amended. Considering the time number of years which has elapsed between the date of compromise between the plaintiff and defendant number 1 and the date of instant petition being filed by the plaintiff side, it is amply clear that there was no due diligence being exercised by the plaintiff side, and there appears nothing by which it can be said that the matter could not have been raised before the commencement of the trial or framing of the issues. The plaintiff side has also failed to show any sufficient ground as to how such a vital point had missed their notice after the compromise between the plaintiff and the defendant number 1. Situated thus, I am of the firm opinion that allowing the prayer for plaintiff would amount to grave abuse of the process of law and would cause injustice to the other parties. Now, your lordship will can
So, is there any time limit for filing amendment petition?
my lord, really, my lord, proviso says, my lord, if the trial has begun, then the plaintiff has to, the person who is seeking an amendment has to show that there without, even after due diligence, that could not be done.
Hmm.
That is Order 6, Rule 17, if your lordship.
Order 6?
Rule 17. Otherwise, my lord, there's no time method. Rule 17. The court may at any stage of the proceeding may allow either party to alter or amend his pleading in such manner and on such terms as may be just, and such amendment shall be made as may be necessary for the purpose of determining the real question in controversy between the parties. Provided that no application for amendment shall be allowed after the trial has commenced, unless the court comes to a conclusion that in spite of due diligence, the party could have raised the matter before the commencement of trial. Here, my lord, in my respectful submission, my lord, it is, my lord, this schedule, my lord, even if the plaintiffs proceed with the suit, my lord, and if he succeed in the suit, my lord, there cannot be an execution because the schedule, the amount of measurement is wrong. And the evidence has not yet been submitted, my lord. The plaintiff evidence has not yet started, my lord. And this, my lord, this amendment will not prejudice anybody.
So, the court below has already framed the issues.
Issues as well. It was fixed for filing of the plaintiff's evidence, and while filing the plaintiff evidence, my lord, it was detected that the after the compromise decree, the amount, the measurement of the land has not been deducted, my lord, and the schedule has
Is
not
there
been
any decision on this point of Supreme Court, Honorable Supreme Court?
find out, my lord. Otherwise, my lord, Supreme Court has said, my lord, the court should not be hyper technical in dealing with the amendment application.
Do one thing, we will pass the order at 2 p.m. In the meantime, you find out any
I'll find.
decision of Supreme
Yes.
Court? We'll see.
Item number 4.
May I please, my lord? My lord, the order passed by the railway claims tribunal is under challenge, my lord. More than interim order was passed by the tribunal, my lord, directing the railways to, my lord, release the goods, my lord, which were kept on lane. My lord, in fact, in this case, my lord, what has happened, my lord, that, my lord, an amount of punitive charges were laid on the, my lord, respondent on the account of misdeclaration of routes. My lord, subsequent to that, my lord, as the amount was not paid by the respondents, my lord, the railways exercised the power of lane under section 83 and, my lord, detained the goods, my lord, and the between order, my lord, is page 32 is the order, my lord, by which the trucks were, my lord, detained by the authorities. Page 32.
Page number?
Page number 32, my lord, annexure 7. Subject, my lord, detain 8 numbers of loaded trucks as an lien from line number 6 against misdeclaration under charge of X RAH rack on 18/10/22. In terms of the subject cited above, that mixed ex GOTN mixed plates for unloading on line number 6 of MR Transport. MR Transport failed to pay the misdeclaration of penal charges as per station record. Now it has been decided by the competent authority to detain 8 numbers of following loaded trucks of the same value of misdeclaration penal charges from your end as lien as per the Railways Act of Section 83. Kindly take action from your end to detain the following trucks until the decision to finalize intimation will be given to you from this office. Now, my lord, the respondent, my lord, filed the OA. Along with the OA, my lord, an interim application was also filed, praying for releasing these trucks, my lord, upon which the powers of lien was exercised by the railway. And my lord, subsequent to which at page 37, my lord, the impugned order is passed. Page 37. My lord, the order is at page 37. Today, the case is fixed for hearing on disposal of interim application of applicant for release of 8 trucks by the respondent railway, exercising power of lien under section 83 of the Act for a demand of rupees 57,82,477 connected with invoice numbers 3, 8, 10, 11, 9 and 12. The corresponding railway receipt number, my lord, so and so, dated 14/10/2022. Now, my lord, the last part of the order, if lordship will see, my lord, there is a direction to release the trucks, my lord, which amounts in the nature of the final relief. Lord, without hearing the main application, Lord, there was a direction to release the trucks, my lord, that would contravene the very provisions of section 83. Lord, there is a direction to release the trucks. Whereas, my lord, prima facie, there was a misdeclaration of goods, and upon which, my lord, the charges were imposed upon the respondents.
So, which is the operative portion of the order?
The operative reviewing portion of the order is, my lord, paragraph 12. On the above discussion, the reasons stated above, herein above, the principles laid down in the referred cases, the interim application of the applicant is liable to be allowed, directing the respondent railway to release the trucks with goods bearing vehicle number, so and so, after taking indemnity bond of rupees 57,82,477. Now, my lord, the basic principles on which the interim order was passed was that, my lord, after the delivery of the goods, my lord, the amount cannot, penal amount cannot be imposed upon the, my lord, the respondents. Whereas, my lord, in the present case, the misdeclaration was found by the authorities, my lord, at the time of destination itself. My lord, will take page 29. Page 29. Page 29 is the report, my lord, regarding collection of due penal charges. If I may read the letter, my lord, a 20 BCN rack was booked in the name of MR Transport at Ramgarh station of Agra division of North Central Railway for Changsari in Assam on 13/10/2022. As part of preventive check, samples were collected from the aforesaid mentioned rack by the Joint Committee of CGS, MTJ, CHI/MTJ and DCI/MTJ and Constable Railway Police in presence of parties representative. So therefore, my lord, this sample was collected at the destination, my lord, from where the this particular sample was supposed to travel from Agra to Changsari in Assam. So the very basis of passing the, my lord, interim order on the ground that the railways have charged the punitive charges after the delivery of the goods, that is, my lord, incorrect, because samples were taken at the destination, my lord, initial point of time only, and my lord, those samples were later on tested and misdeclaration of goods was confirmed from the lab report. That is at page 28. Page 28 is the lab report, my lord. My lord, therefore, my lord, on the grounds of the misdeclaration of goods, my lord, there are certain rates. What the petitioner, my lord, loaded the goods, my lord, and misdeclared the contents of the product, my lord. On the lab report, my lord, it was found that it is chargeable under a different, my lord, category. Page 35, my lord, will also see. Page 35, my lord. Thirty-five A is the typed copy, my lord. 35A is the typed copy.
Page number?
35A, my lord. So that says, my lord, above of the misdeclaration found 7 wagons at originating loading point at Ramgarh station, my lord. RAH, my lord, means Ramgarh station. As per the GSI test report, all details calculation sheet given below for your ready reference. So, my lord, the declaration on the railway receipt, my lord, was given, my lord, as Putti and class 110. Whereas, my lord, as per the GSI test report, the commodity found to be loaded was dolomite and, my lord, of class 145. My lord, will see there are 2 columns. One is commodity Putti and class 110, which was declared by the consignor on the railway receipt. And, my lord, what was found in the GSI report, it was of a different class. So therefore, my lord, punitive charges of 55 lakhs was imposed on the ground of misdeclaration of goods. And since the petitioner was not, the respondent was not paying that said amount, my lord, the subsequent 7 trucks were detained on lien.
Okay, okay. Pardon, Minister,
Lord H. Gupta, my lord.
learned counsel for the appellant. No, learned counsel for the petitioner. This petition under Article 227 of the Constitution of India, read with Section 151 of the Code of Civil Procedure, is directed against the order dated 10/11/2023, passed by the Learned Railway Claim Tribunal, Guwahati, in original application number OA Roman 3-60/2023. It is to be noted here that by impugn order, the Learned Claim Tribunal, Railway Claim Tribunal, Guwahati bench, directed the petitioner to release the goods in favor of the respondents who is kept by railway as lien on non-payment of different demands charge of rupees 57,82,477, subject to furnishing indemnity bond of equal amount. Whereas the petition and the documents placed on record, let notice be issued to the respondent returnable in 4 weeks, is that be taken by registered post with AD and also by usual process within 2 working days from today. call for the scanned copy of the record from the learned court below, no, learned tribunal, until returnable that impugn order dated 10/11/2023. Passed in original application number OA 333-60/2023. Stands state till returnable that list of corporates.
Item 7.
Yes, Your Lordship. Your Lordship, I have challenged that order, Lordship. This is past page number 28, Lordship. Your order is the background of the case is that, Lordship. Sorry. This 37, Lordship. Case is the Lordship, specific purpose of contact case was filed, Lordship. There is a case of decreed, Lordship. But some portion, Lordship, missed out, Lordship. And accordingly, Lordship, even degree was passed, Lordship, degree. But we could not execute the execution could not pass, Lordship. In the execution of state, Lordship, we have to stop, Lordship. Because the defendant side raised objection that since there is no specific order of delivery of possession, so it cannot be executed. That's all, Lordship, passed the order, Lordship, for amendment of some portion, Lordship, and this order was passed, Lordship.
Yes.
Lordship, order gone through, Lordship. So, Lordship, only the portion, Lordship, the order rejected, Lordship. Had only that court said that the section 152 CRPC, CPC and 22 is relief is applicable, Lordship. So, Lordship, this was the correct, Lordship. Actually, the Lordship, where the entire Lordship case is such, Lordship. The delivery of possession, Lordship, it is implied, Lordship. It is the subsequently, Lordship, entitled, Lordship. So, Lordship, in the judgment, Lordship, this part is missing, Lordship. So, we filed the petition under 152 CPC, Lordship. That if there any omission, Lordship, that can be activated, Lordship. So, on the ground, Lordship, I can be, Lordship, I paid, so, Lordship, the trial court's order, Lordship, this is 37 is, Lordship, apparent error, Lordship. And there is also some judgment, Lordship. The judgment also said by the Supreme Court, Lordship, that if there is the issue permanent case is structured, Lordship, then the delivery of possession is ancillary, Lordship. Ultimately, it should be given, Lordship. But that part is not given to me, Lordship. So, Lordship, that may be on direction, only on direction given, Lordship, the trial court, Lordship. So, Lordship, modify that part, Lordship, and accordingly execution may be granted, Lordship. Because I have paid my entire,
So the judgments?
Lordship, yes. So the first first on, Lordship, I am Lordship, Manikam, Lordship, the bold on, Lordship.
Which
Lordship.
paragraph you have relied upon here?
Yes, Lordship, just I'll go to the paragraph, Lordship, 29 and 30, Lordship, last part, Lordship. This is also some other part also their lordship, but this may be lordship, relevant lordship, no relevant lordship. In 30 lordship, married lordship. At 29 lordship, to examine whether the provision of provisionary director mandatory one of the test is that the court is required to ascertain the real intention of the legislature by carefully attending to the whole scheme of the statute. Keeping in view of the scheme of the statute, we find that the section 22(2) of the act is only directory, and thus the decree holder cannot be non-suited for the reason that the such relief was not granted in the decree for specific relief. So in my case also, lordship, when decree holder lost the specific relief was not granted, a delivery position was granted lordship, I will enter to lordship. And 30 says lordship, the defendant in terms of the agreement is bound to hand over the possession of the land agreed to be sold. The expression at any stage of the proceeding is wide enough to allow the plaintiff to seek relief of possession even at the appellate stage also, or in execution even if such prayer was required to be claimed. And this court in Babulal has explained the circumstances where relief of possession may be necessary, such as in a suit for partition or in a case of separate possession where the property conveyed is a joint property. In the suit for specific performance, the possession is inherent in such suit. Therefore, we find that the decree holder are in fact entitled to possession in pursuance of the sale deed executed in their favor. So it is inherent lordship. If the case is structured lordship, the delivery of possession is lordship, ultimately it should be given lordship. And well, lordship, in my case, lordship, the case is structured lordship, because I find the entire amount, the witnesses must establish the case lordship, that's a court granted the relief lordship. And in this judgment also lordship, in the letter judgment lordship, here is also lordship, paragraph 9 lordship, in sub paragraph 7 lordship, where it in some portion lordship, about third line lordship, it is equally settled law that after passing the decree of specific performance, the court does not cease to have any jurisdiction. The court retain control over the decree even after the decree has been passed. So lordship, the decree
Which
lordship,
paragraph you were reading?
lordship, paragraph 9 sub paragraph quoted paragraph 7 lordship. The small judgment lordship.
Yes.
Paragraph 9 last page sub paragraph lordship 7 lordship quoted paragraph.
Mm.
Lordship after 3 line lordship, it is equally settled lordship.
Mm.
In third line lordship, equally it is equally settled law that after passing the decree for specific performance, the court does not cease to have any jurisdiction. The court retain control over the decree even after decree has been passed. Again, lordship, paragraph 10 says lordship. Here also lordship, I am reading lordship after 5th line lordship. Even lordship may have got lordship, even if there is no such direction under such circumstances also, if the condition stipulated under section 28(1) so far deposit of the sale consideration is concerned, and that too within the stipulated time framed by the trial court or any other court in appeal, then a duty is cast upon the trial court to grant the necessary relief for successful end of the decree of specific performance of contract, and to that extent the trial court has the authority to pass necessary relief accordingly.
Mm.
Well, my judgment lordship, here the trial court judgment lordship, there is lordship, relief is granted lordship. The judgment lordship page, lordship, relevant portion come page 25 lordship. Lordship, my case is such lordship.
Page number 25.
25. All lordship, may I come to the issue as lordship? Here 4-5 issuers the lordship, may only lordship. Again, I am coming for the issue as lordship. May kindly come to page 19 lordship for the moment. Lordship, here the 6 issues are there lordship. All the issues are structured lordship in affirmative lordship, in my favor lordship. Page 19 may see the issues lordship. 11 issues will be 3, 4, and 5, 6. Page 19 may come lordship. That six issues are there, lordship. Issue number 3 is relevant, lordship. Whether the plaintiff has paid entire consideration price of the suit land which was fixed at rupees 80,000 per biga to defendant. Issue number 4, whether the plaintiff has fulfilled the condition laid down in Bainanama. 5, whether the plaintiff is entitled to any relief. And 6 also the lordship. Now, lordship, I am coming the issue result of the issue, lordship. Issue number 3 is stated, lordship, here, lordship. Issue number 3, lordship, page 21. Page 21, lordship, and the result, lordship. Result, lordship, page 23 is the issue of issue number 3, lordship. Here, lordship, paragraph 27 says, as such, it is also found to be proved that defendant obtained the consideration amount of 80,000 from the plaintiff and executed the exhibit 1 where he agreed to sell the suit land to plaintiff double detail. So this issue is decided affirmative, lordship. The lordship, my whole consideration amount was taken by them, lordship. So, lordship, ultimately the court granted me relief, lordship. And issue number 4, lordship, here also, lordship, whether I have fulfilled the condition of Bainanama, lordship. This is also, lordship, court says yes. There is page 24, lordship, paragraph 32. Here also says, lordship, in such a case, and upon considering the conduct of the plaintiff, I find that the plaintiff has been ready and willing to perform his part of the contract, and in fact, he duly performed his part as per their agreement of sale. So, lordship, all issues are, lordship, in affirmative, lordship, and accordingly I have granted relief, lordship. But, lordship, now, lordship, the delivery position is subsequent, lordship. Ultimately it comes, lordship. So, lordship, try to, lordship, the whole, lordship, I come, then my own petition is given, then in the relief, lordship, the delivery position was not granted, lordship. It is a typical mistake, lordship, or apparent error, lordship. So, they have omitted, lordship, and accordingly, lordship, I will be granted relief, lordship.
So whether the court below has the power under section 152 of the CPC?
Yes, lordship, that is their lordship.
Hmm?
There is apparent some error, lordship, that is their lordship.
No, error has been taken, error that has been contemplated under the said section is ministerial actions.
Yeah, already omission, lordship, that is
Hmm?
lordship, some fanciful omission also their lordship. Because where the all relief was granted, lordship, that means, lordship, I am also entitled the delivery position also, lordship. Because the court never said that there is some defect, he is not, he can grant some relief or cannot grant some portion. That's not their lordship. If the whole thing I have given, lordship. Not only order sheet lordship, there is the or the direction lordship, there is only this part is not there lordship. So even there is not there lordship, the court have power lordship, then even at even the appellate stage also lordship can be done lordship. But I have not come to the appellate stage, I have filed the petition in that stage also. One 52 says that if there is an accidental slip or omission, that also can be lordship.
We will reserve the order. Heard Mr. S. Learned Counsel for the petitioner. Argument concluded, order reserved.
Order number 8.
Hello. This is my first appeal against management refusing to allow the probate. Hello. The appeal judgment is page number 41 if you can, madam.
No. So why the probate application was dismissed?
My lord, there is on two grounds, my lord. Firstly, the court said that signatures are mismatching. But my lord, please that the opposite party is never taken plea of signature mismatch. They have therefore that plea was not there at all. That plea was not there. Then there are other mistake in application of evidence also, my lord. Firstly, my lord, kindly see that the court held that signature is mismatching, my lord. May kindly see that. At page number 57, my lord.
50?
Page 57. Oh, 98, running page 96. Running page 96, my lord. On comparing signature with naked eye appearing in lead petition of Shyam Kolita Exhibit 4 and signature appearing in will Exhibit 2, it seems that the signature are different. But my lord, there was no pleading that signatures are not accepted. Rather, from the pleading, it appears that signatures has been admitted. My lord, may I kindly see that objection, my lord. Objection filed by the defendant, my lord.
Okay, we will admit the appeal.
My lord.
Heard Mr. S. Sharma, Learned Counsel for the appellant. This appeal under section 299 of the Indian Succession Act 1925, read with section 96 of the Code of Civil Procedure, is directed against the judgment dated 30th/4/2024, passed by the learned. Additional District Judge number 1, Kamrup, Guwahati, in probate title suit number 2 of 2014 under section 276 of the Indian Succession Act 1925. It is to be noted here that while impugned judgment, the learned trial court had dismissed the application filed by the appellants seeking probate. Now, for granting probate, for obtaining letter of administration of last will dated 12/4/2006 of this is Shyam Kolita. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment dated 30th/4/2024. Admit. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. SSL call for the call for the record from the learned trial court. List the matter after 4 weeks.
Item number 9,
Let me share, my lord. Mistake is also there, my lord. Regarding stay,
item 9.
stay over.
Okay, yeah, there also notice will go. We'll consider now next date.
মানে operation of the implementation state, otherwise.
On next date we'll consider.
Item 9.
Discuss next date. Soon notice. It will be considered on next.
Wait, wait, wait. This revision of under section 115 of the Code of Civil Procedure is acted against an order passed by the trial court rejecting the petitioner who was a dependent manner. The application for rejection of claim under order 7 rule 11 on the ground of manner bar of limitation manner. Manner, the suit was filed for, it's a commercial suit manner, filed for recovery of around 80 lakhs, I think. Yes, 80 lakhs. And we filed an application for rejection of the plaint on the ground that the suit is
Barred by limitation.
barred by limitation. My lord,
What is the limitation period?
3 years, my lord. 3 years, because this is a case where the plaintiff's case is that they have supplied materials to the defendant and time to time invoices were raised. And the last invoice was raised and delivery was made in the year 2016. That is, my lord, 30th of July 2016, which your lordship will find at page 57, man. That's the part of the plaint. Page 57, man.
Yes.
Para 80.
Hmm.
This is the last supply manner. Thereafter, against the aforesaid supply, the plaintiff issued an invoice bearing number so-and-so dated 30th of July 2016 respectively for a sum total of rupees so-and-so. As per the terms of invoice, payment was due within 30 days. Such invoice was accepted without any demur or protest. Copy of the said invoice forms part of the plaint, etc. So this is the last. In earlier paragraphs also, they have given the statement about the supply made earlier, and this is the last. Now this is in July 2016. Now, in terms of Article 14 of the Limitation Act, it will be the limitation period will be three years from the date of delivery of the goods, because it is suit is for recovery of cost of goods delivered.
Article 14.
14. I'll come to the provisions at a time later when I refer to other provisions also. So that way, my lord, apparently the suit ought to have been filed sometime in the month of July 2019. From 2016, 3 years.
Hmm.
So sometime in July 2019, the suit should have been filed. But admittedly, the suit was filed on 28th of June 2023. 28/6/2023.
Hmm.
But after these pleas were raised, my lord, although they have filed the suit of more than about 2-3 years after the limitation period expired,
Hmm.
there were 2 events, subsequent events, based on which they are claiming that limitation period is still there, and that is in terms of Article Section 18, that is acknowledgement, my lord, your lordship is aware, if there is an acknowledgement before the expiry of the period, a fresh period of limitation starts.
Hmm.
I'll refer to that while I'm just making my submissions. So in terms of Section 18 of the, my lord, Limitation Act, as well as Section 19 of the Limitation Act, they are saying that their suit is within time. For that, lordship may kindly come to what is their stand, my lord. Lordship may kindly come to page 58. I'll show the relevant paragraphs of the plaintiff.
Yes.
The defendants page
Hmm.
58, para 82.
Yes.
Defendants, in spite of repeated requests, failed and or neglected to make payments against the outstanding invoices. Several meetings were held with the concerned dealing officials of the plaintiffs and the defendants for release of payment. Such meetings were held at Guwahati Office of Defendants within the jurisdiction of this learned court. As such, since the defendants were unable to make payment of its admitted dues, defendants, by way of a balance confirmation statement, confirmed a sum of rupees 46 lakhs 12,038 as due and payable as on 1/7/2018. This is one date and on which they are relying. Such balance confirmation statement has been received within the jurisdiction of this learned court for PNX. Next paragraph, para 83. A perusal of said balance confirmation statement would reveal that defendant number 2 clearly acknowledged its liability on behalf of defendant number 1, and therefore the defendants are jointly liable to make payment of the outstanding dues to the plaintiff. As per the defendant's own admission in the said balance confirmation statement dated 1/7/2018, the entire payment was to be made in 2 tranches in the month of July 2018 and August 2018. Next paragraph was the important. This is a different aspect, para 84. However, the said promise to pay within August 2018 was not adhered to and or honored by the defendants, despite requests and reminders and assurances. Subsequently, defendants made an ad hoc payment of rupees 10 lakhs on 28/11/2018 as on 15 May 2023. Sorry, 28/11/2018. As on 15 May 2023, the plaintiffs had raised invoices for a sum of rupees 46 lakhs 12,715, out of which a sum of rupees 10 lakhs has been received. Copies of the bank statements confirming the payment of rupees 10 lakhs forms part of the plaint and is marked as so and so. In view of the aforesaid, the plaintiff is entitled to claim an aggregate sum of rupees 80 lakhs 93,000, which includes outstanding principal amount of rupees 36 lakhs 12,000 and odd, and 44 lakhs 80,000 and odd towards interest accrued from the date of default till 15/5/2023 from the balance from the defendants under the following claims to set out above in the following manner. Total admitted, this is the table manner, total admitted by ledger dated 1/7/2018 is 46 lakhs something. Paid rupees 10 lakhs on 28 November 2018, balance 36 lakhs, interest 44 lakhs, etc. So these are the 2 things. And lastly, there is one more aspect, my lord. They are relying on one more aspect that your lords will find at page 61. There is para 89 about an oral agreement. May I repeat? After receipt of the said notice, some legal notice probably was issued. After receipt of the said notice, the defendants represented and assured to the plaintiff that the entire outstanding amount shall be paid by the defendants within the month of August 2021. As such, an oral agreement was entered into by and between the parties on 21st of June 2021 at the office of the plaintiff situated at Guwahati branch near so-and-so, Guwahati so-and-so, within the jurisdiction of this court. And then next page, para 91, they are again referring to that oral agreement. Second sentence, the agreement to pay was lastly entered into by and between the parties on 21st of June 2021. So these are the three, my lord, events based on which they are actually claiming that although the suit was filed 3 years after the date of delivery or the invoice, but still it is within time because there were some events and based on which they are claiming exclusion of time or rather extension of time of limitation. Now, Lordship may kindly see the paragraph where, my lord, in a suit, my lord, plaintiff states how the cause of action has arisen and how the suit is filed in limitation. For that, Lordship may kindly turn to page 64, para 95. Inasmuch as the cause of action for the instant suit arose on 1st of July 2018 and thereafter on November 28, 2018, when the defendants only made part payment of their dues and thereafter, lastly on 21 June 2021, when the parties to the suit entered into an oral agreement wherein the defendants again promised to pay within the end of August 2021, no part of cause of action is barred by limitation. Now, Lordship, I'm just indicating, I'll be elaborating in my submission, my lord. So far as the first date is concerned, that is 1st of July 2018, on that day, they say there has been an acknowledgement of debt. And for that, in terms of section 18 of the Limitation Act, they are entitled to extension of the period of limitation for another 3 years from this date. Next is November 28, 2018, when they claim that there has been a part payment of rupees 10 lakhs. So if there is a part payment, there will be again extension of another 3 years from the date of part payment. And this is in terms of section 19 of the Limitation Act. It is their case, my lord. And lastly, there is a oral agreement. And according to them, from the date of oral agreement also, a limitation period of 3 years can be counted. It will be for them to justify, my lord. My submission will be, there is no law in the Limitation Act where, my lord, by way of an oral agreement, the period can be extended. First part, second part is all right. Third part, my lord, there is nothing in law. Anyway, I'll come to that, my lord. Now, Lordship will kindly see, apart from this, my lord, there is one more aspect is there. Your Lordship is aware during Corona period, my lord. There was a case in the Honorable Supreme Court, the Suomoto case. There, the Honorable Supreme Court has granted some extension in respect of some cases. That also.
All right.
My lord,
That was excluded.
part was excluded. How that was excluded? There is a reason, my lord. Which part is excluded, which part is not? I'll come to that. That is also there, and not the entire period, my lord. Supreme Court has indicated. I'll come to that. Now, Lordship may kindly see, I have calculated the limitation period. Well, I'm sorry, madam. Before that, I'll have to take your Lordship to the two documents. One is balance confirmation statement, another one is payment of 10 lakhs. In terms of the, or rather in support of the pleadings made in the plaint, they have produced two documents. One document of balance confirmation that will
Page number
page 72.
72.
My
72.
This is from the Lordship has got page 72.
Yes.
This is on top, my lord, there are two addresses. One is addressed to, that is the plaintiff, and right hand side is the address of the, my lord, sender. Dear so-and-so, subject confirmation of accounts. And they've given the period, and the date of this confirmation is 1/7/2018. Similar on the right hand side. This is the date they have referred in their paragraph, which I have shown just now. And they are also relying on, my lord, this document and the handwritten facts and figures, July 20 lakhs, then August so-and-so, etc. my lord. So at least subject is given balance confirmation statement. Second document you will find at page 73, next page, my lord. This document is not legible. Somewhere they say this is a part of their, possibly their ledger account showing payment of or receipt of 10 lakhs from the defendant. These are the two documents based on which they say that on 1st of July 2018, there was a balance confirmation statement by the defendant. And second is payment of 10 lakhs on, Twenty-eight 11/2018. Lordship, may I kindly take note of these two dates, my lord. First document is 1/7/2018. And second is 28/11/2018.
Where the date is mentioned?
My lord, page 60, they have mentioned the pleading. In this document, it's not legible. Nothing is
Page
legible.
60.
My lord. Anyway, let us accept for the time being, my lord, that it is 28/11/2018.
Lordship, providing with the commercial student actually.
No, it's all right. It's all right.
It is there.
My lord, let us accept that this is the date. I'm not disputing right now, my lord. 28/11/2018. I'm just praying that this date may be noted, my lord. So these two dates are very important, by 1/7/2018, 28/11/2018. And there is a third date which I'll come later on, my lord, 28 June 2020. Now, my lord, Lordship may kindly have a look at page 99. I have given the whole schedule, my lord.
Page 99.
Page 99. My lord,
Yes.
my lord, as I have stated, the last supply was in July 2016. So in terms of the provisions of Article 17 of the Limitation Act, the period expires after 3 years. That is in 17, 18, 19. So that way suit is barred. Now we have to see whether suit is saved by way of these two documents. For that, my lord, what I have done, my page 99, I have prepared it. We have prepared a table, my lord. Balance confirmation statement was 1/7/2018, my lord, which lordship has seen. Now, if we go by balance confirmation statement, which they say is an acknowledgement in terms of section 18 of the Limitation Act, and section 18 says if before the expiry of the period of limitation, there is an acknowledgement, a fresh period of limitation will
Start.
So let us accept that this is the legal position. Subject to, my lord, in the trial, whether they can succeed or not, it's a different thing, my lord. Prima facie, they have shown in the plate. We cannot dispute that at this stage. In the trial, what happens, we don't know. For the purpose of considering an application under Order 7, Rule 11 of rejection of plaint, my lord, whatever is there in the plaint, we have to accept to be correct as minus the written statement. Now, if 1/7/2018 is the date of balance confirmation statement, and from there, a first period of 3 years will be there. Next row, lordship will kindly see, total period of limitation, that is 1/7/2018 to 2/7/2021. Lordship has seen 3 years. So if we accept the date of 1/7/2018 to be the date from which a fresh period of limitation has started, then the period will expire on 2/7/2021. Am I clear? Now, next one, lordship will kindly see, limitation exhausted till 15/3/2020. I'll come to the Supreme Court judgment a little later, my lord. Supreme Court says on 15/3/2020, we have to see how much of balance period you are left with before, if the period has started running before that. So from 1/7/2018, that is the starting date in the above row, my lord, to 15/3/2020 is 623 days. Now, next is remaining period of limitation to file the suit is 1095 minus 623 is 472 days. Am I clear, my lord? Now, calculating 472 days from 1/3/2022. This again is a date from the Supreme Court judgment when I'll come to that. The date given by the Honorable Supreme Court, suit must have been filed on 16/6/2023. Adding, my lord, 472 days from 1/3/2022, they have got time 472 days, which will expire on 16/6/2023. But the suit was filed on 28th of June 2023, and there is a delay of 12 days. This is going by the, my lord, balance confirmation statement. But we have got one more hurdle to overcome. That hurdle is a payment of 10 lakhs, which they claim that we have made a payment of 10 lakhs. And in the trial, whether they succeed in proving that we have made a part payment of 10 lakhs on 28th of November 2021 is a different thing. But at this stage, in a petition after order 47, order 7, rule 11, my lord, that question can be gone into. It has to be accepted that there was a, for the time being, that there was a part payment of 10 lakhs. Let us accept, because in the plaint, whatever is there, at this stage, we have to accept it to be true. Now, next question, my lord. I'm sorry, my lord. Before that, I have to clarify the Supreme Court's order, because I have made use of the exclusion of period from the Supreme Court order, my lord. I mean, in the Supreme Court, the Suomoto case of writ petition number 3 of 2020, from time to time, orders were passed. My lord, time to time orders were passed, and this is the last order, my lord. This is relevant. That is why I have given a copy of this order. Okay, possibly I need not read the entire order. This paragraph 5 will be, my lord, sufficient for our present case. Paragraph 5. Taking into consideration the arguments advanced by learned counsel and the impact of the surge of virus on public health and adversities faced by litigants in the prevailing conditions, we deem it appropriate to dispose of MA number so with the following directions. The order dated 23/3/2020 is restored. This is an earlier order. And in continuation of the subsequent orders dated 8/3/2021, 27/4/2021, and 23/2021, it is directed that the period from 15/3/2020 till 28/2/2022 shall stand excluded. What we have seen, my lord, this is the period which I have taken, my lord. From 15/3/2020 to 28/2/2022 shall stand excluded. First, for the purposes of limitation as may be prescribed under any general or special laws in respect of all judicial or quasi-judicial proceedings. Next, Roman 2, my lord. Consequently, the balance period of limitation remaining as on 3/10/2021, if any, shall become available with effect from 1/3/2022. Now, we fall in the third category. There is a third category, my lord. In cases where the limitation would have expired, this is important. In cases where the limitation period would have expired during the period from 15/3/2020 till 28/2/2022, notwithstanding the actual balance period of limitation remaining, all persons shall have a limitation period of 90 days from 1/3/2022. In the event the actual balance period of limitation remaining with effect from 1/3/2022 is greater than 90 days, that longer period shall apply. And the meaning of this order is that from 15/3/2020 till 28/2/2022 shall exclude it. This part my learned friend is also not disputing. Whatever is there in the Supreme Court, we have to accept. So that way, my lord, our lordship will kindly see here. In our case, the limitation period expires on 2/7/2021. Second row I have mentioned, my lord. Counting 3 years from the balance conformance statement. As your lordship see. So 2/7/21 comes within the period mentioned in the third paragraph. It says if it expires within 15/3/2020 to 20/2/2022, the actual balance period remaining as on 1/3/2022 will be counted. So before 15/3, my lordship has seen, my lord. Before 15/3, in my table, I have come again, my lord. Since the period of limitation started rolling from 1/7/2018, in the second row I have given, my lord. So limitation period exhausted till 15/3/2020, we have to find out first. Before the exclusion given by the Supreme Court. Supreme Court has said from 15/3/2020, you will get the exclusion. So before 15/3/2022, a period has already expired when there was no impact of COVID-19. That period we have counted 623 days. And then in the third paragraph of the Supreme Court judgment says, after 1/3/2022, whatever period is remaining, minimum is 90 days. And if there is a longer period remaining, the entire period will have to be excluded. Then we have done, my lord, we have got 472 days left. Now from 1/3/2022, in terms of the Supreme Court judgment, we have added 472 days, which comes to 16/6/2023. So that way, the suit should have been filed on or before 16/6/2023. Suit was filed on 20/6/2023. So there is a delay of 12 days. This calculation I have given for the purpose of calculating the period of limitation from the date of balance confirmation statement. Now the second hurdle, my lord. They say there has been a payment of 10 lakhs by the defendant to the plaintiff. And for that, your lordship will kindly permit me to read two provisions of the Limitation Act, section 18 and 19 first.
Limitation. Section 14.
Section 18 and 19 are relevant, my lord. 18, I need not read. 18 is very clear. Effect of acknowledgement in writing. If there has been an acknowledgement, a fresh period of 3 years will, my lord, start running. There is no dispute with this proposition of law, my lord. If this balance confirmation statement is 1/7/2018, then there will be an extension of 3 years. 19 is important here, my lord, in respect of that second hurdle, as I have said, my lord, payment of 10 lakhs. Effect of payment on account of debt or of interest on legacy. Where payment on account of a debt or of interest on a legacy is made before the expiration of the prescribed period by the person liable to pay the debt or legacy, or by his agent duly authorized in this behalf, a fresh period of limitation shall be computed from the time when the payment was made. They have made a statement in the plaint, my lord, that on 28/11/2018, a payment of 10 lakhs was made by us. So according to them, my lord, in terms of section 19, a fresh period of limitation will again start running from 28/11/2018. If that is so, then the suit is within time. I am also accepting, my lord, that if 28/11/2018 is accepted to be payment of 10 lakhs by us. Within the meaning of section 19 of the Limitation Act, there will be an extension of another 3 years. But then difficulty in this case is, my lord, section 19 has a rider. Merely because a payment is made, this benefit of extension of another 3 years will not be available to them unless this second part is fulfilled. Second part, there is a proviso, my lord. Provided that, say in the case of payment of interest made before 1st day of January 1928, that we are not concerned, but we are not in 1928. So straightway we can read, provided an acknowledgement of the payment appears in the handwriting of or in a writing signed by the person making the payment. Lordship has seen, there is a proviso. Merely because a payment is made, part payment is made of the debt, will not be enough to seek extension of time of another 3 years from that date, unless the plaintiff is also able to show that there has been an acknowledgement of the payment in the handwriting of or in a writing signed by the person making the payment. Whoever has made the payment, there has to be a handwriting or as signed by the person who makes the payment. This payment may be by the person himself or by his agent, but then it has to fulfill the second condition, that it has to be in the handwriting of or in a writing signed by the person making the payment. And my submission before Lordship is that this second requirement is not there in our case, and second requirement, my lord, is not pleaded in the plaint. Now the question is, if it is not pleaded in course of evidence, you cannot prove it. The Lordship is aware, my lord, law is very clear. No amount of evidence can be looked into or allowed to be led if there is not supporting pleading in the plaint or in the written statement. In our case, we raised a plea that now at this stage, when the Honorable Court is considering an application under Order 7/11 for rejection of plea on the ground of power of limitation, court has to see only the plaint averment and nothing else. What we have stated in the written statement cannot be considered. We may deny many things, but our denial will not be taken into consideration at this stage. Whatever they have stated in the plaint has to be accepted to be correct for the purpose of at least Order 7, Rule 11. Now, in this case, my lord, there is one more aspect which needs consideration. Lordship may kindly have a look at the written statement. And the written statement starts from page 74. But then this statement which they have made about payment of 10 lakhs, my lord,
Yes,
possibly Lordship is rising person.
yes. After 5 minutes.
To the plaint first.
Para 18 of the written statement.
Para 84 of the plaint at page 59. Where they have claimed that there has been a payment of 10 lakhs on 28/11/2018.
No, you have already shown it.
No, I'm showing this because this statement made in para 84 of the plaint has been replied by the defendant in their written statement, which your lordship will find at page 90 and para 38. Because they will be relying on this, that is why I'm saying showing them. Lordship is para 38 at page 90. That with regard to statements made in paragraph 82 and 84, in these two paragraphs, they have mentioned about this matter. The answering defendants beg to state that the statement of the plaintiffs with regard to meetings being held in Guwahati for release of payment is irrelevant in as much as no such meetings took place at Guwahati. Now, this is important. The defendants paid a sum of rupees 10 lakhs on 28 November 2018 against the claim of the plaintiff, and further payment was not made due to non-settlement of the disputed bills wherein the goods were supplied at higher rates. With regard to the balance confirmation statement, it is when so, the answering defendant doesn't admit anything contrary to the records of the case. Then para 40 also, my lord. There, with regard to the statements made in paragraph 86 and 87 of the plaintiff, the answering defendants deny the same and beg to state that after receiving the aforesaid sum of rupees 10 lakhs on 28/11/2018, the plaintiff was silent and did not seek any payment in time, and due to such negligence of the plaintiff, the limitation period for filing a suit to seek the remaining disputed amount had lapsed. So this is the reply given by the defendant in response to the, my lord, statement made in paragraph in plaint about part payment of 10 lakhs on 28/11/2018. Lordship has seen, my lord. My lord, based on this statement made in the written statement, an argument will be made, because it was made before the court below, my lord, that the requirement in proviso to section 19 that there has to be an acknowledgement in writing is discharged. The burden to show that there is an acknowledgement in writing, the burden is discharged because you have almost admitted in the written statement that you have made a payment of 10 lakhs on 28/11/2018. So therefore, the next, the burden of the plaintiff to show that in terms of proviso to section 19, that there has been an acknowledgement in writing is discharged.
Trial court hold.
No, madam, trial court has not held. I'll come to that later. I am just showing the argument on behalf of them is that whatever burden I have under the proviso to section 19, that there has to be the payment, acknowledgement payment of part payment has to be in writing, signed by the person making the payment. There is no statement in the plaint. But since you have made a admission in the written statement, so that admission has to be treated to be the fulfillment of the requirement of the proviso to section 19, that it is an acknowledgement in writing by the person who is made the payment. This is the argument. Now I have to counter to that, my lord. For that, my lord, my submission is, my lord, that whether the suit is barred by limitation or not has to be decided only on the basis of averments made in the plaint, and no part of statement made in the written statement can be looked into. This is number one. And secondly, after the suit has been filed, first submission is, my lord, the plaintiff has the burden to show that the prima facie the suit is filed within the period of limitation, and the entire burden is on the plaintiff. And perusal of the plaint averment must show that suit is filed within time. Anything beyond plaint cannot be looked into. This is my first submission. Secondly,
Is there any legal framework on this point?
yes, my lord. Yes, I'm coming to that. There is a judgment of the Supreme Court directly on the point. My second submission is, my lord. Second submission is that any material coming before the court after filing of the suit will not come in the aid of the plaintiff to discharge his burden under proviso to section 19. These are the two submissions, my lord. Now, for that, my lord, first I'll take your lordship to a judgment of the Supreme Court reported in AIR 1951, Supreme Court, page 477.
Where?
Absolutely similar.
Paragraph number?
Para 8, 9, and 10, my lord. These three paragraphs will suffice.
Yes.
Lordship, may kindly see paragraph 8, man.
Hmm.
Admittedly, in the case before us, none of the payments specified above was endorsed on the bond itself, and there was no acknowledgement either in the handwriting of or signed by the debtors prior to institution of the suit, like our case, madam.
Hmm.
What the subordinate judge relied upon is the admission contained in paragraph 15 of the written statement filed on behalf of the defendant number 1 to 3 in the present suit, where those defendants admitted not only that the payments specified in the plate were actually made on the respective dates, but asserted that there were other payments besides this, which reduced the debt still further and for which the plaintiffs did not give any credit to the defendants. In the opinion of the subordinate judge, as the written statement was signed by these defendants, it would fulfill all the requirements of a signed acknowledgement as is contemplated by the proviso to section 20. Before amendment, it was section 20, which has been quoted above. The short point for consideration is whether the view taken by the subordinate judge is correct. It would be clear, we think, from the language of section 20 Limitation Act that to attract its provisions, two conditions are essential. First, payment must be made within the prescribed period of limitation, and secondly, it must be acknowledged by some form of writing, either in the handwriting of the payer himself or signed by him. We agree with the subordinate judge that it is the payment which really extends the period of limitation under section 20 Limitation Act. But the payment has got to be proved in a particular way, and for reasons of policy, the legislature insists on a written or signed acknowledgement as the only proof of payment and excludes oral testimony. Unless, therefore, there is acknowledgement in the required form, the payment by itself is of no avail. The subordinate judge, however, is right in holding that while the section requires that the payment should be made within the period of limitation, it does not require that the acknowledgement should also be made within that period. To interpret the proviso in that way would be to import into it certain words which do not occur there. This is the view taken by almost all the high courts in India, and to us it seems to be a proper view to take. Next paragraph. But while it is not necessary that the written acknowledgement should be made prior to the expiry of the period of limitation, it is, in our opinion, essential that such acknowledgement, whether made before or after the period of limitation, must be in existence prior to institution of the suit. So this admission made subsequent to the institution of the suit is of no consequence. Next sentence, my lord. Whether a suit is time barred or not has got to be determined exclusively with reference to the date on which the plaint is filed and the allegations made therein. You have to rely on your own statement. The legislature has expressly declared in section 3 of the Limitation Act that whether the defense of limitation be pleaded or not, the court is bound to dismiss the suit. And this is very important. Bound to dismiss the suit, which is brought after the period provided, therefore, in the first schedule to the Limitation Act. If the plaintiff's right of action is apparently barred under the statute of limitation, that is so Order 726 CPC, makes its duty to state specifically in the plaint the grounds of exemption allowed by the Limitation Act upon which he relies to exclude its operation. And if the plaintiff has got to allege in his plaint that the facts which entitle him to exemption, obviously these facts must be in existence at or before the time when the plaint is filed. Facts which come into existence after the filing of the plaint cannot be called in aid to revive a right of action which was dead at the date of suit. To claim exemption under section 20 of the Limitation Act, the plaintiff must be in a position to allege and prove not only that there was payment of interest on debt or part payment of the principal, but that such payment has been acknowledged in writing in the manner contemplated by that section. The ground of exemption is not complete without this second element, and unless both these elements are proved to exist at the date of filing of the plaint, the suit would be held to be time barred. This is my submission. going to take a plea that in the written statement you have admitted, so my burden is discharged. The Honorable Supreme Court says no. You have to make the statement, you are claiming an exemption under section 19. In order to claim exemption under section 19, the fact that you have fulfilled the requirement of the proviso must be pleaded in the plaint, and that has to be done before filing of the suit. After filing of the suit, if there is something in the written statement, as in this case, my lord, will not be of any aid to the plaintiff. Now, my lord, there is a check. Then I'm relying on another judgment, my lord, 2020 16 SCC 601. I'm furnishing a copy of judgment. My lord. At page 610, para 6.8, my lord, the judgment in Madanuri Sri Ramachandra Murthy has been relied on. I am just referring to that paragraph, my lord. There's paragraph 7 of that Madurai. And a line about maybe 10th or 11th from the bottom. The averments, see, my lord. The averments in the written statement as well as the contentions of the defendant are wholly immaterial while considering the prayer of the defendant for rejection of the plaint. Even when the allegations made in the plaint are taken to be correct as a whole on their face value, if they show that the suit is barred by any law or do not disclose cause of action, the application for rejection of plaint can be entertained and the power under Order 7, Rule 11 can be exercised. If clever drafting of the plaint has created the illusion of a cause of action, the court will nip it in the bud at the earliest so that bogus litigation will end at the earlier stage. Now, just another paragraph I'm relying. Right hand side, Lordship may kindly go. Para 9 at the bottom.
Yes.
Now, so far as the application on behalf of the original plaintiff and even the observations made by the learned trial court as well as the High Court, that the question with respect to limitation is a mixed question of law and facts, which can be decided only after parties lead the evidence is concerned, as observed and held by this court in so and so and so and so and so. Considering the averments in the plaint, if it is found that the suit is clearly barred by law of limitation, the same can be rejected in exercise of powers under Order 7, Rule 11D. There's one more judgment. 2020, Volume 7 SSC, page 366. Only there I'm relying on a short paragraph in paragraph 23(3) at page 377.
Yes.
Short paragraph. The underlying object of Order 7, Rule 11A is that if in a suit, no cause of action is disclosed or the suit is barred by limitation under Rule 11D, the court would not permit the plaintiff to unnecessarily protract the proceedings in a suit. In such a case, it would be necessary to put an end to the sham litigation so that further judicial time is not wasted.
Okay.
My lord, one more plea they have taken in the written statement, plaint, in the paragraph where they have mentioned about the date when the cause of action arose. That is 21st of June 2021. And according to them, the cause of action has arisen on that date also because there was a oral agreement that I'll make the payment. my lord, with regard to this plea in the plaint, my lord, my submission is very clear. There is no law which extends the period of limitation on the basis of an oral agreement made after the expiry of the period. My lord, my submissions are like this. My lord, my first submission is taking into consideration the suo motu direction, the direction of the Honorable Supreme Court in the suo motu case, my lord. They have got benefit of execution of some time. But as I have shown in the calculation, my lord, from the period starts running from 1/7/2018, and the Honorable Supreme Court has given the benefit from 15/3/2020 to some date in 2022. But in our case, my lord, two things are there. Before 15/3/2020, already a period of 623 days has been exhausted. And this calculation is there in page 99. And when the Supreme Court my lord says that from 15/3/2020 till 28/2/2022 will be excluded, this question cannot come because before that our limitation period expires on 2/7/2021. So therefore, my lord, since we fall in the third category, the third, there are 5 Roman 3. There it says from 1st March 2022, the remaining period of limitation will be excluded. So on 1st of March 2022, there was a remaining period of 472 days. And if that is excluded, the last date for filing the suit comes to be 16/6/2020. And I have not, so that way my suit is clearly barred. From the date of balance confirmation statement, it is clearly barred. From the date of part payment, my lord, they cannot take the plea, they cannot save the limitation because they have not fulfilled the requirement of section 19. They are trying to take shelter under the statements made in the written statement, which according to the Honorable Supreme Court is not permissible. Whatever is there in the plain, that can be only relied on. And lastly, my lord, I have not shown anything from the impugned judgment. My lord, impugned judgment is available at page 100 of the revision application. My lord, I had the opportunity of appearing before the learned court below also in this case. I have pointed out my learned friend also appeared against me. So I have pointed out all these judgments, particularly this 1951 Supreme Court. But there is no reference of 1951 Supreme Court in the entire order. And what has happened, my lord? The learned trial court, Lordship will kindly see at page 101. Second paragraph, plaintiff filed written objection in which it is stated that defendants in para 38 of the written statement stated that the defendants paid a sum of 10 lakhs on 28/11/2018 against the claim of the plaintiff, and further payment was not paid due to non-settlement, etc. So this paragraph is quoted. Thereafter, my lord, it is stated that the admitted date by the defendant regarding transaction between the parties is on 28/11/2018. That is the part payment of 10 lakhs. Supreme Court then, my lord, the learned trial court has gone to the Supreme Court suo motu judgment. Para 5 has been quoted, 1, 2, 3. Then next, my lord, the paragraph at the bottom, Lordship will see. The admitted date of transaction between the parties, we are not concerned with any admitted date of transaction. We are concerned with any part payment, if any, made of the debt during the period of limitation. Somehow learned court below has written the admitted date of transaction between the parties is on 28/11/2018. And in such case, suit ought to have been filed normally by 28/11/2021 with 3, that should be within 3 years limitation. However, the period from 15/3/2020 till 28/2/2022 shall stand excluded for the purpose of limitation. The period of exclusion from 15/3/2020 to 28/2/2022 is 624 days shall be available on 1/3/2022, being longer than 90 days, and hence the last date of filing the suit will be so and so. As per the Supreme Court's order, The present suit has been filed on 28/6/2023, and therefore the suit is very well within the limitation. It is stated that the point raised by the plaintiff that an agreement was entered between the parties on 21/6/21 is for the plaintiff to prove during trial of the case, and suit cannot be dismissed at this stage on the grounds of limitation. It is further stated that the law of limitation is mixed question of law and fact, and the court in deciding application under Order 7 Rule 11 has to consider the copy of the plaint without going to the underlying documents, hence prayed to consider. Heard both sides, Peru's case record from the pleading as well as submission of the parties, it is seen that the defendants paid an amount of rupees 10 lakhs on 2018 to the plaintiff against the claim of the plaintiff. That being so, the period of limitation will run from 2018. As per order, it is so and so of the Supreme Court, the period from 15/3/20 till 20/2/22 shall stand excluded for the purpose of computing the period of limitation. As per said order, in cases where the actual balance period of limitation remaining is more than 90 days, the longer period shall apply. In cases where the balance period is less than 90 days, then 90 days will be given as grace period. In the instant suit, it is seen that the defendant paid some amount out of the total outstanding amount to the plaintiff of 2011-2000. It is 19 return, it should be 18 minor. In the normal circumstances, the period of limitation would have expired on 2011-2021, but this date has fallen within the period of excluded by the Supreme Court. As on 2/3/2022, the plaintiff had balance period of 1 year, 8 months, 15 days till the month of November 2023. Plaintiff filed the suit in the month of June 2023. Hence, it is found to be within the period of limitation. And therefore, the petition is rejected. My lord, with all respect, my lord, my submissions that you have to fulfill the requirement of provisional section 19 has not been considered. The judgment of Honorable Supreme Court of 1951 that has not been considered. And the court, learned court below repeatedly says the period from 15/3/2020 till 28/2/2022 will be excluded. My lord, in this case, the period of limitation itself has expired in 2021, even assuming that there was an acknowledgement. So the question of exclusion till 2022 will not arise. Supreme Court has made it very clear. Now, I think I have made repeated submissions on that. I will not repeat again. So from 1st of March, they are entitled to have the period counted, remaining period counted from 1st of March. And if from 1st of March, the remaining period of 472 is counted, the period expires on 16/6/2023. Now, your lordship has to consider whether the payment of 10 lakhs which they claim to have made to the defendant in the plaint, whether it is in terms of section 19 or not, and whether the Honorable Supreme Court has said that whatever statement he made in the written statement will be of no use to them. That your lordship will consider. In that way, the matter may suit is covered by limitation, and the learned trial court has committed a grave error or malady not considering all these materials. That's my submission.
My lord. I started from the place where my learned senior has stated that if the payment is made on 28/11/2018 rupees 10 lakhs, then it is within limitation subject to the proviso of section 19. Now, my lord, without much repetition, my lord, may I pray, my lord, to come to paragraph 84. Paragraph 84 of the plaint, that is in page 59 of CRP.
Yes.
My lord, second line of paragraph 84. This is my pleadings. Subsequently, the defendant made an ad hoc payment of INR 10 lakhs on 28 November 2018. My lord, I have also enclosed the bank statement, which is in page 73 of payment of 10 lakhs. CRP 73, which is also provided by my associate learned friend. in
Hmm.
the trial brief.
Hmm.
So there, the payment is made by RTGS, my lord,
Hmm.
10 lakhs on 28/11/2018. Now, my lord, may I pray before my lord to come to page 90 of CRP.
Yes.
Paragraph 38 of written statement. My lord, 6th line from top of paragraph 38. It is an admission. The defendant paid a sum of rupees 10 lakhs on 28th November 2018 against the claim of the plaintiff, and further payment was not made due to non-settlement of the disputed bills, wherein the goods were supplied at higher rates. So, my lord, on 28th November, they have paid rupees 10 lakhs that they have admitted without any dispute, my lord.
But whether it will fulfill the requirement of the proviso to
Yes, my
section
lord.
19?
I would so, my lord, how it is going to fulfill the proviso, my lord. My lord, I'm passing on it. How my suit survives because of that.
Thank you.
My lord, page 2 of my brief, small brief written.
Hmm.
Now question is how my suit survives.
Hmm.
That is written, my lord, in number 2 serial number.
Hmm.
Second line of argument, which is very important and confirmatory argument for the respondent plaintiff. Defendant has admitted in the written statement that part payment of rupees 10 lakhs is made on 28/11/2018. My lord. Next page. The part payment is within limitation, even if we consider the date of first indent, that is 3rd day of February 2016. Same is mentioned in paragraph 10C of my affidavit in opposition at page 16 of affidavit in opposition, last paragraph. That I have pleaded that even if we consider it from the first indent, which has been given for supply of order, first indent, it was a continuous business from the first indent. Even if we consider, then also that payment is made within 3 years, my lord. First date of indent is mentioned in paragraph 7 of plaint, page 26 of CRP, my lord.
Hmm.
My lord, in paragraph 7. That accordingly, an indent dated 3rd February 2016 was issued by the plaintiff in favor of defendant number 1 for supply of a edge cutting machine. My lord, that is the first indent, that is 3rd February 2016. And limitation would end on 2nd of February 2019, and this payment is made on 28/11/2018, my lord. My lord, they have also, the defendant, petitioner defendant has also confirmed that in paragraph 14 of WS, the first date of indent, in page 77 of CRP. Paragraph 14 of WS. My lord, if we read the last but one line, with regard to invoices, purchase order, and supply of goods, the answering defendants do not admit anything contrary to the relevant records of the case. So they have admitted that first date of indent, and that from first date
The
of
question
indent
is,
within
can we look into the written statement?
my lord,
can we look into the written statement in view of the decision referred by Mr.
My lord, I tell, my lord, if my lord see the citation which I have given, my lord,
Mm,
of the Supreme Court,
mm,
my lord would come to para 8, last line of that citation.
Yeah.
Ivan Lal Acharya versus Rameshwar Lal Agarwala.
mm,
My lord, it states, my
Mm.
lord has got the last line.
mm.
It is not in dispute that the proviso to section 20 is compelled with, in this case, for the check itself is an acknowledgement of the payment in the handwriting of the person giving the check. So, my lord, in this case, it is not order 7 rule 11. During the trial, this has come into whether the check is a valid acknowledgement or not. In RTGS, my lord, a check has to be given for RTGS to the bank. And that we are going to prove it during trial, my lord. That is written acknowledgement. Suppose, my lord, I give a check to my colleague. He encased it to, he deposited his bank account, and the check is within the custody of the bank. That we have to call for in the trial. We cannot produce it in here, in this plaint. By calling the official witness and official document, we would call it from bank, and then we would prove the case, my lord. My lord, and going by the other, that there is a oral agreement on,
So according to you, this section 19 is not attracted.
my lord,
Whether
there is
it
one
is
more
the
thing, my
section
lord, there
20
is-
that is
my
attracted
lord,
here.
one more thing, my lord,
Hmm.
that proviso, I need not prove it also because it is an admitted fact under order 12 rule 6. My lord, if my lord see order 12 rule 6, judgment on admission, that I need not prove it because he has already, during trial, I need not prove it because in written statement, he has already admitted. The defendant has admitted that rupees 10 lakhs has been given. What order 10 or order 12 rule 6 says, my lord?
No, that's why my question was, can we look into the written statement?
Yes, my lord, because we have this, and if we consider his pleading that I have not pleaded that I am going to prove the case by producing my bank check at the custody of the bank, then they would not, they have also not objected in their written statement that they have admitted that this order 7 rule 11D petition has come at a subsequent stage.
Hmm.
In the written statement, they should have contested that we have not paid and the plaintiff is liable for strict proof of that payment of check. That they have not said, my lord.
Hmm.
So now order 12 rule 6, that is why the learned court below has used the word admittedly
Hmm.
in the alleged impugn order, my lord. My lord, what order 12 rule 6 says, where admission of fact have been made either in the pleadings.
No. You are not answering my question. If we cannot look into the written statement at that stage, where is the admission then?
My lord, my written statement states that
Yeah.
payment has been made by them and it is I have given the bank account,
Hmm.
bank statement, my plain.
Hmm.
So it is not that I have kept everything in under shadow, I have not
No, the
disclosed.
question, then the question is, how the proviso is satisfied?
My lord, I would have to, during trial, I would call for, my lord, again, another thing is that I am taking my There is an oral contract. I am taking my cause of action from that
No,
oral.
is there any provision in the Limitation Act about oral agreement?
Yes, my lord, yes,
Where?
my lord, yes, my
Where?
lord. That is what I am going with that, my lord.
Yes,
Article 113,
113.
13. Suit for which there is no prescribed period. Any suit for which no period of limitation is provided elsewhere in this schedule, 3 years, when the right to sue accrues.
No, where is the reference of this oral agreement?
No, oral agreement is not there, but everything, all aspect of law cannot be covered within this Limitation Act under this. So Limitation Act has given a specific provision where it is not covered, it is 3 years.
No, then we have to presume that the oral agreement,
Oral
provision of
contract is a valid
oral
contract,
agreement
my
is
lord.
there in the Limitation Act.
Yes, my lord. We'd have to presume that it is 3 years, my lord. Because if it is not, if we agree, if we go by what my learned senior has said, that there is nothing mentioned in the Limitation Act, okay, I agree with it. But there is a provision. If nothing is mentioned, then it is 3 years. My lord, I would like to show two provisions of Commercial Act, my lord.
No, we are not on the merit of the case, so we are on the
No, my lord,
limitation point
I
of
have to
limitation.
show this to my lord.
Pardon?
For this, my lord, because Section 16 of Commercial Act says that wherever there is amendment to CPC, then that part of amendment would follow for CPC. And in this, if we see for Order 12, Rule 6, there is no amendment. So that judgment on admission would follow. That cannot be obviated, or that cannot be removed. That we would have to go by Commercial Act. So this is not going to follow. Order 12, Rule 6 is not going to follow. So this should have definitely an impact, and that is why the learned court below has admittedly taken that date of payment, 28/11/2018, that both the parties have agreed. So it is the date of from where limitation has to be construed. So my lord, it is a correct order. Whether it is impliedly or whatever it is a correct order on the part of learned court below, my lord. My lord, this, my lord, I would like to show, if we consider this to be an interlocutory order, impugn order, then, my lord, I would pray, my lord, to go to Section 8 of the Commercial Courts Act.
No, how can it be an interlocutory order?
Because it is not determining the main suit, it is determining only.
No, not because of that. If we allow the application, then the matter ends there.
Yes, my
Then how it is interlocutory order?
My lord, I read this. Notwithstanding anything contained
You
in
are reading
Section 8 of Commercial Courts Act.
Section 8. Yes, bar against revision.
Revision application or petition against an interlocutory order. Notwithstanding anything contained in any other law for the time being in force, no civil revision application or petition shall be entertained against any interlocutory order of a commercial court, including an order on the issue of jurisdiction. Any such challenge subject to provision of Section 13 shall be raised only in an appeal against the decree of a commercial court. My lord, even if we consider it to be a decree of commercial court, then also they would have to go to commercial appellate court under Section 13. What Section 13 says, my lord? Appeals from decree of commercial court and commercial divisions. The word is using is decree. Any person aggrieved by the judgment or order of a commercial court below the level of a district judge, it has been passed by civil judge too, Kamrup Metro, may appeal to the commercial appellate court within a period of 60 days from the date of judgment or order. Which they have not done, my lord.
So according to you, they have to approach this appellate court.
Commercial appellate. Whether it is a decree or order. If I say that it to be interlocutory order, then also they would have to go, even if it is a decree, then also they would have to go to commercial appellate court, not as a civil revision petition here.
So in view of this two sections, this petition is not maintainable according to you.
So even if it is maintainable, then also in merits I have a case on 2 count, my lord, that the payment is made, interim payment is made from a period wherein from which there is limitation, which I can prove it in court by calling the record of the check and RTGS papers. And otherwise also, if we consider the oral contract, that whether my case, whether I succeed in the case or I fail in the case is a different thing to be considered in the trial court.
We are only on the point of limitation.
Yes, my lord.
That can be.
Yes, and Mr. Mozumdar, is this order against which this revision petition is preferred is an interlocutory order?
No, it's not integrated. This will finally decide the suit itself. The suit will go, suit will be dismissed. One argument has been repeatedly made that there is an admission in the written statement. First of all, there is no reply to the submissions I made based on the 1951 Supreme Court judgment. That anything made, any admission made in the written statement cannot be taken into consideration for the purpose of fulfillment of the requirement of section 19, number 1. And my lord, judgment on admission is something different. If I admit a claim of the plaintiff, that admission in the written statement can be taken to be admission of the claim, and based on that, a decree can be passed. Here they are saying that I have admitted their contention that a payment was already made. It's not an admission of claim. It is assuming that they are saying that it's an admission. I am not admitting right now, my lord. It is an admission of a statement made in the plaint about payment made earlier. It is not an admission of the claim that yes, I am liable to pay you say 10 lakhs. Order 12 that has been relied on speaks about admission of a claim made in the plaint by the written statement. Based on that, judgment can be passed. Not an admission of claim.
My lord, only 2 lines.
Yes.
And just 1 minute. The judgment which my learned friend is relied on, saying that was a judgment in a, my lord, in a case of under the Negotiable Instruments Act, first of all. And secondly, says it is not in dispute that the proviso to section 20 is complied with in this case, for the check itself is an acknowledgement. Here, there is no averment at all on the basis of which you are claiming exemption. As the Honorable Supreme Court has clearly said, if you are claiming exemption under section 19, you must clearly plead in the plaint that this is how I am claiming. There is nothing. So this judgment will not come to the aid of the man.
My lord, only
Okay.
2 lines. My lord, I need not claim for exemption, because if I consider the oral contract from 21/6/2021, I am within limitation, my lord. So I need not claim exemption. Exemption would come under Order 7, Rule 6 of CPC, my lord. There, my lord, it states, where the suit is instituted after the expiration of period prescribed by the law of limitation, plaintiff shall show the ground upon which exemption from such law is claimed. But I am showing a oral contract. Whether I succeed in the trial or not is a different thing. I am showing a oral contract, taking the submission of my learned senior that only the plaintiff has to be relied upon. Then from that oral contract, I am within limitation. I need not claim any exemption.
And secondly, 37.
What are the submissions made with regard to section article 113 of the Limitation Act is a completely different thing, my lord. Has no application to our case. It says any suit for which no period of limitation. In our case, article 17, lordship may kindly have a look, it's clearly attracted. 14. It is for price of goods sold and delivered where no fixed period of credit is agreed upon 3 years from the date of delivery of the goods. This is the article attracted. So there is a specific period of limitation. So the question of application of article 113 will not come at all. That's all.
Heard Mr. D. Mozumdar, learned senior counsel assisted by Mr. Dewey.
Right.
Learned counsel for the petitioner and Mr. Sina. Learned counsel for the respondent. Argument concluded, order is out.
Deeply over.
Here the impugned order under challenge is the order by which WS was not allowed to be filed, your lordship. I have also filed an additional affidavit bringing on record the medical documents that were also placed before the lower court. The impugned order is at page 46, starts from page 46, your lordship. The operative part at page 49. Page 49, lordship, second last paragraph. I may read your lordship. Lordship is there?
Yes.
From the medical reports, it appears from the date of receiving the summons, in no occasion the defendant number 1 was admitted in hospital, or the reports do not show that he was under such physical inability that he could not consult the engaged advocate to file his written statement within the period under Order 8, Rule 1 of the CPC. The ground was that in the petition that was filed, your lordship, that he could not contact the advocate, your lordship, during that period. So there was a delay in filing the WS. From the medical documents which I have annexed, your lordship, before that, your lordship, the summon was served to me on 13/3/2024.
Serve on
13/3/2024.
Hmm.
So ideally, it expired at the time of 90 days, expired on 13/7/2024. So 13/6, your lordship. Three months. 6/2024. So from the medical documents now, your lordship, that I have annexed at page 55 is the first medical document. 55 is the photocopy. 54 is the type copy. The additional affidavit. It is a document much prior to that, your lordship. 2/8/23. Your lordship may note the date at the top right side at page 55. 2/8/23. It is a prescription from a doctor at Chennai, Apollo Chennai, your lordship. Page 55. Thereafter, continuing, your lordship, page 58 is another prescription, 21/12/23. Then page 60, 23/24. And finally, in page 62, 31/5/24. All these are prescriptions from Chennai, your lordship, at a gap of 2 months each, your lordship, 2 to 3 months between all these prescriptions, your lordship. So the ground that was projected by the defendant, your lordship, that he was visiting Chennai every 2 months, your lordship. So he could not contact the advocate and file the WS within time. And he filed it on 22/7/2024 along with this petition under 151 with a prayer to accept it. but the court rejected since he was not admitted at any point of time to show that he could not consult his advocate. My humble submission is that the defendant, the petitioner herein, visited Chennai every 2 months, Your Lordship. Under such circumstances, it was a kidney ailment, and specifically in page 55, Your Lordship, may peruse the prescription. It is also advised that the entire family of the petitioner needs screening, ultrasound of the abdomen relating to the disease that he was suffering. It may be hereditary, Your Lordship. Page 55, the first advice in the prescription itself, Your Lordship. It says the entire family needs screening of the abdomen, Your Lordship. So under such circumstances, there was 1 month delay in filing the WS, Your Lordship, which was filed immediately before the suit has proceeded, Your Lordship. It was rejected.
Okay, heard Mr. Vijay Mukherjee, learned counsel for the petitioner. This petition under Article 227 of the Constitution of India, the petitioner Gauri Kanta Brahma has put to challenge the correctness or otherwise of the order dated 22/7/2024, passed MTS number 12 of 2024, passed by the learned civil judge, Junior Division Kokrajhar. It is to be noted added by the impugn order dated so and so, the learned civil judge, Junior Division Kokrajhar, refused to accept the written statement filed by the defendant filed by the petitioner as defendant number 1. Mr. Mukherjee, learned counsel for the petitioner, submits that the petitioner is a defendant in title suit number 12 of 2024 instituted by 1 Oneshwar Brahma and 2 others before the Court of Learned Civil Judge, Junior Division, Kokrajhar. And in the said titles, the petitioner has received summon on, who is that? 13/3. 13/3/2024. And the period of 90 days for filing the written statement expired on 13/6/2024. Mr. Mukherjee, referring to the medical document enclosed at page number 55, to 92 in the additional affidavit submitted by the petitioner, submits that the petitioner is suffering from chronic kidney ailment and he used to visit Chennai in every 2 months. And on account of his illness, he could not contract his engaged counsel and therefore he could not file the written statement in time. And thereafter, where is the petition you have filed before the trial court?
Is that page 26?
Thereafter, on 22/7/2021, the petitioner approached the learned civil judge, Junior Division, Kokrajhar, by filing a petition under section 151 of the CRPC to accept a written statement. But the learned trial court, by the impugn order dated so and so, has dismissed the petition on the ground that the medical report submitted by the petitioner disclosed that on no occasion he was admitted in hospital. And the documents also failed to disclose his physical inability for which he could not consult his engaged counsel to file a written statement within the stipulated period. And thereafter, referring to a decision of Honorable Supreme Court in the case of Salem Advocates Bar Association, within bracket 2 versus Union of India, reported in 2005, 6 SSA 344. The learned trial court has dismissed the petition as he failed to show any exceptional ground, exceptional circumstances of his failure to file a written statement within 90 days from the date of receipt of the summons. Mr. Mukherjee further submits that the order so passed by the learned trial court cause serious prejudice to the petitioner in as much as he used to visit Chennai on account of his ailment in every 2 months. Every 2 months, and that if the petitioner is not allowed to submit a written statement, serious prejudice also be caused to him, and therefore it is contended that the petitioner may be contended to allow this petition. Having heard the submission of learned counsel for the petitioner, I have carefully gone through the petition and the documents placed on record, and also perused the impugned order dated 22/7/2024 and the medical documents enclosed with the additional affidavit from page number 54 to 90, 54 to 92. The medical documents disclose that the petitioner is suffering from chronic kidney diseases, and it also appears that in every 2 months he used to visit Chennai for his treatment. And having considered above, and also considering the submission of Mr. Mukherjee, and also the decision of Honorable Supreme Court in the case of Advocate Bar Association, Salem Advocate Bar Association, within bracket Supra, this court is left unimpressed by the observation made by the learned trial court in the impugned order dated 22/7/2024 that no exceptional circumstances is shown by the petitioner for his failing to submit written statement within 90 days. The medical condition, as indicated by the documents mentioned herein above, indicates that the same are exceptional circumstances for which he failed to submit his written statement within time. Under the above mentioned facts and circumstances, this court is inclined to allow this petition. The impugned order dated 22/7/2024 is then set aside and quashed. The learned trial court is directed to. Have you filed a written statement
Yes, sir.
before the trial court?
Yes, Your Lordship.
Where you have
In
enclosed
the
it?
petition itself, Your Lordship, at page 26.
The learned trial court is directed to take on board the written statement submitted by the petitioner, and thereafter
Para
proceed
3,
to
page 27.
hear and dispose of the suit in accordance with law. In terms of this CRP stands to dispose of.
Timing array number 3.
Wait, please. Sir, I find out two judgments. Sir. One, well, place two judgments. Lordship remembers the here the issue is, well, so whether the trial court could have rejected the amendment application. Well, the 2009 judgment, your Lordship will take Vidya by judgment. Well, it clearly nullifies, in fact, the applicability of proviso of Order 6, Rule 70 as had been done by the trial court. Well. Your Lordship turns to the internal page 4 of the judgment. Well. Para
Paragraph
8,
number?
my lord.
Paragraph number?
Paragraph number 8, my lord. The question that arose before the Honorable Apex Court was, my lord finds Para 8.
Yes.
From the order passed by the learned trial judge, it is evident that the respondent had not been able to fulfill the said precondition. The question, therefore, which arises for consideration is as to whether the trial had commenced or not. In our opinion, it did. The date on which the issues are framed is the first hearing. Provisions of CPC envisages taking of various steps at different stages of the proceeding. Filing of an affidavit in lieu of examination of chief of the witnesses, in our opinion, would amount to commencement of the proceeding. Now, your Lordship will kindly turn to page 7, internal page 7.
Yeah.
Para 12, my lord. In between, my lord. Reliance line starts from Reliance, however, has been placed by so and so versus so and so reported in so and so where it was opined. Before we part with this order, we may also notice that proviso to Order 6, Rule 17 provides that the amendment of the pleading shall not be allowed when the trial of the suit has already commenced. For this reason, we have examined the record and find that in fact, the trial has not yet commenced. It appears from the record the parties have yet to file their documentary evidence in the suit. From the record, it is also appears that the suit was not on the verge of conclusion as found by the High Court and the trial court. That apart, the commencement of trial as used in proviso to Order 6, Rule 17 in the CPC must be understood in the limited sense as meaning the final hearing of the suit, examination of witness, filing of the documents, and addressing of arguments. As noted herein above, the parties are yet to file their documents. We do not find any reason to reject the application for amendment of written statement in view of the proviso to Order 6, Rule 70, which confers wide power and unfettered discretion to the court to allow an amendment of the written statement at any stage of the proceeding. It is not an authority for the proposition that the trial would be deemed to have commenced on the date of first hearing. It is in that case, as noticed herein above, the documents are yet to be filed, and therefore it was held that the trial did not commence. Now, you admit undisputedly, my lord, from the impugn order, my lord, it is clear. It is at the stage of filing of evidence by the plaintiff, my lord. And the other judgment, my lord, 2023 recent judgment, my lord, where the powers under the proviso of Order 6, Rule 17 has been discussed. And finally, the Honorable Apex Court, in the internal page of Para 13, page 13. Before that, my lord will kindly take page 11 of the judgment. The proposition is with regard to Order 6, Rule 17, Para 33. My lord finds page
Para 30.
Para 33.
Yes.
There cannot be any doubt or dispute that the court should be liberal in allowing the application for leave to amend pleading, but it is well settled that the court must bear in mind the statutory limitation brought about by reason of the CPC. The proviso appended to Order 6, Rule 7 being one of them. In so and so versus so and so, the law has been laid down by this court in the following terms. Insofar as principles which govern the question of granting or disallowing the amendment under Order 6, Rule 17, as it stood at the relevant time are concerned, these are well settled. Order 6, Rule 17 postulates amendment of pleading at any stage of the proceeding. In so and so, in Pirgula Hong Patil, the reported in so and so, which still hold the field, it was held that all amendment ought to be allowed which satisfied the two conditions: A, not working injustice to the other side, of being necessary for the purpose of determining the real question in controversy between the parties. Amendment should be refused only where the other party cannot be placed in the same position if the pleadings had been originally correct, but the amendment would just cause him an injury which would not be compensated in the cost. Now, your lordship will kindly turn to page 13, Para 36. In between, my lord, the all the earlier judgment has been discussed. In para 36, relying on a recent judgment of the Honorable Apex Court. In one of the recent pronouncement of this court, this in the case of Life Insurance Corporation versus Sanjeev Builders, in civil appeal number so and so, the proposition of law has been explained as under. Matlab, these principles are called out. All amendments are to be allowed which are necessary for determining the real question in controversy, provided it does not cause injustice or prejudice to the other side. This is a mandatory as is apparent from the use of the word shall in the later part of Order 6, Rule 17 of the CPC. The prayer for amendment is to be allowed if the amendment is required for effective and proper adjudication of the controversy between the parties to avoid multiplicity of proceeding. The amendment does not result in injustice to the other side. By the amendment, the party seeking amendment does not seek to withdraw any clear admission made by the party which confers a right on the other side. The amendment does not raise a time-barred claim resulting in divesting the other side of a valuable accrued right. A prayer for amendment is generally required to be allowed unless by the amendment a time-barred claim is sought to be introduced, in which the case of the fact that the claim would be time-barred becomes a irrelevant factor for consideration. The amendment changes the nature of the suit. The prayer for amendment is malafide. The amendment, the other side loses a valid defense. In dealing with a prayer for amendment of the pleadings, the court should avoid a hyper-technical approach and is ordinarily required to be liberal, especially where the opposite party can be compensated by the cause. Where the amendment would be enabled, the court could pinpointedly consider
Not required to read entire paragraph.
Yes.
Alright.
In fact, my lord, now if your lordship will find in the written statement also, my lord, of the defendant number 2 and 3, who are the parties now, contesting parties in the suit. Their claim is in respect of, my lord, defendant number 2, 1 bigha, defendant number 3, 4 bigha, 2 katha, 10 lesa. So they do not have any claim in respect of the claim of the defendant number 1, in which there has already been a compromise decree drawn up. So this nowhere is going to prejudice the defendant number 2 and 3 of the contesting party. Because if your lordship finds the impugn order, page 41. The operative portion from page 43.
Paragraph number?
Paragraph number 5. May I read it? Upon perusal of the same, it is crystal clear that the compromise with the defendant number 1 had taken place on 23/7/2018, subsequent to which the compromise decree was also drawn up accordingly. It appears that the subsequent to the said compromise with the defendant number 1, numerous petitions for praying amendment of the plaintiff were filed by the plaintiff side, which were allowed. The petition under Order 6 was filed by the plaintiff on the date of compromise itself, did not contain the prayer for allowing them to make the said amendment in the schedule, as has been prayed by the instant petition. It is even the subsequent to the compromise with the defendant number 1, numerous prayer for amendment of the plaintiff were by the plaintiff side on so and so. But none of the said prayers included the amendment of the schedule and the boundary as prayed for the instant. Now, after an elapse of 6 years from the date of compromise of the plaintiff with the defendant one, the plaintiff had on so and so filed the instant petition for amendment of the schedule and the boundary of the suit land on the ground that the schedule has changed after the compromise of the portion of the suit land with the defendant number 1, which had taken place in 2018. Now, my lord, the proposed amendment which has been sought for, my lord, your lordship will find page 36 is the petition, my lord.
Yes.
Page 37, para 4, my lord. After compromise with the defendant number 1 in respect of 1 bigha 3 katha 4 lesas land out of the total measuring, land measuring 6 bigha 1 katha 12 lesa, there remains a disputed land measuring 4 bigha 3 katha 8 lesas in illegal possession of the defendant number 2. Therefore, the plaintiff ought to have amended the schedule B along with the boundary at the relevant time. At the time of preparation of the evidence of plaintiff witness, it comes to the knowledge of the plaintiff that the schedule of the plaintiff is required to be amended as under. A plot of land measuring 4 bigha 3 katha 8 lesas covered by the tag number so and
Okay,
so.
all right. Where is the line? File before the
Plain starts from page 15. Schedule B, my lord, will find at page 20.
15.
Yes. Plain starts at page 15, 15. The schedule B, wherein the amendment has been sought, is page 20. Here your lordship will find land measuring 6 bigha, 1 katha, 12 lesa. Originally, it was the disputed land.
Okay.
And the compromise decree, my lord, will find page 23.
So what is the ground for which the trial court has refused to entertain your prayer?
Only by the on the ground that as it is in the trial has commenced under
Where, which part of the order?
my lord,
Para number?
para number 7, my lord. Page 44. Considering the stage that the issues in the instance should have already been framed, I am of the opinion that the circumstances of the suit need to be examined keeping in perspective.
Okay. Heard Mr. Kaushik, learned counsel for the petitioner. Correctness or otherwise of the order dated 25/4/2024 passed by the learned civil judge senior division Lakhimpur in title suit number 5 of 2018 is challenged in this petition. Under Article 227 of the Constitution of India. It is to be noted here that by the impugned order dated 25/4/2024 passed in title suit number 5 of 2018, the learned civil judge senior division has dismissed the petition filed by the petition number. What is the number?
288 to
Petition number 288/2024 for amendment of the petition. No, amendment of the plaintiff. Under order 6 rule 17 read with section 151 of the CPC.
Well, petition number will 289. 289.
288 relates to what?
288, my lord, one application on the same date that a
289,
separate petition has been filed with order 6. That was an adjournment. Page 36 is
the background facts leading to filing of the present petition is enumerated herein below. The petitioner as plaintiff had instituted a title suit being PS number so and so before the Court of Learned Civil Judge Senior Division North Lakhimpur for
page 19. Yeah.
for a decree by evicting defendants and demolishing the semi-permanent house constructed by the defendant over the suit land and to hand over possession to the plaintiff and to grant permanent injunction against the defendant from entering into the suit land after granting decree in favor of the plaintiff. Thereafter, notice was issued to the respondent, and accordingly, the respondents appear before the learned trial court, and thereafter, the defendant number 1 entered into a compromise with the present petitioner. Upon which the learned fourth below head. Where is the decree?
Page 23.
Had allowed the compromise petition and decreed uh, uh, um, no, and allowed the petition for compromise against the defendant number one and dispose of the same on compromise and prepared the decree. Thereafter, the respondent, no, thereafter the defendant number 2 and 3 of the said title suit entered appearance before the learned trial court and submitted their written statement. And thereafter, the learned trial court had framed the issues on, who is that?
The issues. It is not mentioned, it is said that the issues has been framed.
But in the order, it is reflected that the issues have been framed.
Issues has been framed.
Issues frame the issues. And thereafter, the present petitioner filed a petition for amendment of the plaint, especially the schedule B, as he had effected compromise with the defendant number one in respect of a plot of land measuring 1 kotha,
1 bigha, 3
1
katha, 4
bigha,
lechas.
1 bigha,
3 katha, 4 lecha.
1 bigha, 3 kotha, 4 losa.
Out of the total measuring, 6 bigha, 1 katha, 12 lecha.
Out of 6 bigha,
6 bigha, 1 katha, 12 lecha.
12 losa, 12 losa, lesa.
Page 37, para 4.
S. His claim is for a plot of land measuring 4 bigha, 3 katha, 8 losa, covered by periodic patta number 57, dag number 151 and 53 of Dikho Mukhia revenue map of Nauvoisa Mauza under Nauvoisa revenue circle of Lakhimpur district. But the learned trial court has dismissed the petition on the ground that it had already framed the issues and the circumstances of the suit need to be examined keeping in perspective of the proviso to order 6 rule 17, which postulates that no application for amendment shall be allowed after the trial has commenced, unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of the trial. The learned trial court also observed that in the context, the learned counsel for the plaintiff side had submitted that at the time of preparing evidence of the plaintiff's witness, it come to the knowledge of the plaintiff that the schedule of the plaintiff is required to be amended. However, the learned trial court has dismissed the pair. By impugn order dated so and so on the ground that the pair of the plaintiff would, no, allowing the pair to the plaintiff, pair of the plaintiff would tantamount to grave abuse of the process of the law and would cause injustice to the other party. Now, the question before this court is when the trial would commence. Mr. B. Kosik, learned counsel for the petitioner, submits that referring to a decision of Honorable Supreme Court in Vidyabai and others versus Padmalata and another reported in
2009 to SCC 409.
2009
To SCC 409.
to SCC 409, especially to paragraph number 8 of the aforesaid judgment, submits that the date on which the issues are framed is the date for first hearing. And the provision of the Code of Civil Procedure envisages taking of various steps of different stage of the proceeding. Also, filing of an affidavit in lieu of examination in chief of the witness, in our opinion, would amounts to commencement of the proceeding. And as here in this case, the affidavit in lieu of examination of chief of the witnesses were not filed. And as such, the trial, according to Mr. Kosik, has not started here in this case. Mr. Kosik also referred to another decision of Honorable Supreme Court in Sudhan's, in Ganesh Prasad versus Rajeshwar Prasad and others, reported in
AIR 2023 SC Civil 1184.
AIR
2023 SC Civil 1184.
This SSC is not there.
SCC melody, I'm not sure whether the citation would be correct or not. 2023 to SCC 375.
23 SCC
2023 to SCC 375.
that without amendment of the plain, if a decree is passed, then the same would not be executable as as after compromise of the suit with the defendant number 1, the claim of the petitioner, the petitioner struck plaintiff in respect of the suit length would be only 4 biga,
Should be 4 biga 3 katha.
3 katha 8 lessa,
8 less.
covered by periodic pattern number 57, tag number 151 and 53 of the Mukhya revenue map under Naoboisa Moja. Naoboisa Moja and Naoboisa revenue circle of the district Lakhimpur. Referring to paragraph number 36 of the aforesaid judgment, Mr. Kosik further submits that where the amendment is sought before commencement of the trial, the court is required to be liberal in its approach. And since here in this case, the trial has not commenced, Mr. Kosik submits that his petition may be allowed by setting aside the impugned order of the learned trial court. Having heard the submission of Mr. Kosik, learned counsel for the petitioner, I have carefully gone through the petition and the documents placed in the record, and also gone through the relevant provision of law, that is the proviso of Order 6, Rule 17 CPC, and also gone through the decisions referred by him. Since, in view of the decision of Honorable Supreme Court in the case of Vidya Bhai and other Sukra, the trial commenced only after filing of affidavit in lieu of examination in chief of the witnesses. And as here in this case, the plaintiff, the petitioner as plaintiff had not submitted the affidavit in lieu of the examination in chief of the witnesses. This court is of the considered opinion that the trial has not commenced, and as such, there is no bar in amendment of the plaintiff. In view of above, this court is of the view that there is a sufficient merit in this petition, and accordingly, the same stands allowed that this motion is itself. The impugned order dated 25/4/2024, passed in title suit number 5 of 2018, stands set aside and plus the matter is remanded back to the learned trial court. And to with a direction to allow the petitioner to amend the schedule B, Schedule B
Schedule P.
of the plaintiff.
Terms
And
of the petition
thereafter
number
to
289.
thereafter proceed to hear and dispose of the petition in accordance with law.
Item number 11,
Grateful. I love.
Losses with application by the insurance company.
Yes.
On the 3 points. That during the calculation of the loss of dependency, that in the income factor, that the income tax was not deducted. Secondly, it was a head-on collision, the contributory negligence of the disease was not taken into consideration. The third point is that lump sum accuracy amount paid by the employer has not been deducted by calculation of the compensation. So on the last occasion, lawsuit, we just know whether the income tax. The question is who will deduct the income tax? In that I have found some judgment lawsuit. Because in the judgment and order, the member MSCT has ordered that it should be deducted. Lawsuit, but if lawsuit kindly come to the kindly come to page 24. Page number 24 from my F2 memo. The internal page 15 of the judgment. Lawsuit. Para 25. The calculation part. Yes. May I read it? Therefore, consider the fact that age of the disease was 25 multiplies 13. The loss of dependencies calculated as annual income is taken as 42,486 without any deduction. Into 12. So 5 lakhs Iman has come, multiplied 13 Iman, deduction 1/4 Iman.
loss of total dependency is 49 lakhs 76. Considering this 30% loss of fixed person made. Loss if the income tax is deducted as from this 30% calculation will be also be different loss. Because if 30% has been calculated on 4970, the income tax is because the amount will come less. Then the 30% amount of that amount will be calculated. The whole calculation will be different. Loss in this regard.
No, my question is,
Yes,
who will deduct the income tax?
Loss on that loss. I want to take some. Yeah. It is specifically mentioned that tribunal should deduct the income tax. Loss the first judgment and to refer to the initial value it was Sushil Sharma versus Chitra Singh. Decided on
Where is the relevant paragraph?
Relevant paragraph, Lordship, page 2, para 8. Lordship may come to the page 3, last line of the para. We may, however, hasten to add that from the said amount of income, statutory amount of tax payable, thereupon must be deducted. Lordship. Second, I am to reply to the Constitutional Bench judgment of Permanent City, Lordship. 2017-6 SCC 680. Last page, para 59.3.
Para
59.3. Constitutional Bench, Permanent City. National Insurance versus Permanent City. 59.3. Here also, sir, Lordship, the last line, actual salary should be read as actual salary less tax. While determining the additional 50% excess of the income of the disease towards a future prospect, where the disease has a permanent job and was below 40 years, should be made. The addition should be 30% in the age of the disease between 40 to 50. In case of disease was between the age of 50 to 60, the addition should be 50%. The actual salary should be to read as actual salary less tax. Lordship, next I am to refer to the latest judgment of 2020-11 SCC 356, National Insurance Budget, Virendra and others. Lordship, para 19 is the relevant process. Para 19, page 367, last para. Lordship, may I read? Reverting to the determination of compensation amount, it is noted that the tribunal proceeding to divide the compensation amount on the basis of net salary drawn by the DS, but a relevant period as so and so, while taking note of the fact that her gross salary was so and so, presumably below taxable. Consequently, the deduction from the gross salary other than tax amount should be reckoned. In that, this is important, the actual salary less tax amount ought to have been taken into consideration by the tribunal for determining the compensation. Specifically, the tribunal has to take into account actual salary less tax amount in calculation of compensation. In light of the dictum of the constitutional bench of this court in para 59.3 of Pranay, I have already shown the Pranay. Yeah.
Yes.
My lord, my learned friend's basic arguments is on the quantum of the award. So my humble submission is today, my lord, that the 50% award will be given, maybe deposited before this court, my lord, and the matter will be heard at length, my lord, because this plea has never been taken in the trial court, my lord, and whether this income, that is the salary, whether it falls under the income group category or not, that is also not been questioned, not a whisper has been made in the entire proceedings, my lord. Now in the appellate stage, where the tribunal has specifically given a liberty to the company, my lord, if any tax is required to be deducted, that may be done. Instead of doing that, my lord, they have came this filing this appeal law.
Lordship,
Where is that order? Trial court order?
Tabular order is with my lord. Lordship will find at page 25, my lord. Relevant portion, order part, my lord. Of the appeal menu.
Hmm.
May I read, my lord?
Hmm.
Accordingly, the claim petition is allowed by awarding rupees so and so only, which is to be paid by the opposite party. Number 3, New India Insurance Company Limited, subject to payment of tax, if any, my lord. That liberty is given. In the trial, they never raised this question. They never even asked whether this disease was an income tax pay person or not, my lord.
Lord,
Okay,
And
then
then
we admit the appeal.
subject to payment of 50%, my lord, because
Hmm.
this claimant, my lord, is suffering from brain tumor, my lord. This claimant is suffering from brain tumor once she has undergone a surgery, my lord. And next time now,
Okay,
she is
okay.
required. Then, my lord, short date for hearing, my lord. I am ready to do the hearing, my lord. Otherwise,
No,
till today, the claimant has not given a
no,
single penny, my lord.
we will admit the appeal subject to depositing 50% of the amount.
Yes, my lord,
Yes.
but in this is special circumstance, my lord, the petitioner is suffering from brain tumor and she has already undergone some surgery, my lord, in Chennai. And subsequently, she is required another subsequent medical treatment, my lord. And this is the urgency, my lord. This is special circumstances, my lord.
So there is a specific direction in the judgment.
Lordship,
Yes, my lord.
Lordship. Specific line is given Lordship.
Hmm.
But the whole I have shown the whole the calculation amount if the tribunal itself has deducted tax. In initial, the whole calculation will be different. The total amount will not come to 66 lakh itself, Lordship. Moreover, Lordship, I have other grounds also I have said. The second is my contributory negligence. I don't
Okay. Heard Mr. A. Asarje, learned counsel for the appellant, and Mr. B. Sonda, learned counsel for the respondents.
May I submit one line statement, my lord? If my lord's submission is on this only on income tax part, my lord, then my submission will be, my lord, that matter will be returned only to the learned lower court, my lord, tribunal, my lord, to decide only this factor, my lord, income factor, my lord.
No, Lordship, I have other grounds also, Lordship.
Then, my
May
lord,
it be
I have
admitted?
objection. Then I have objection.
Okay, we'll hear the matter.
Yes, my lord, short date, my lord.
Lordship, it may be admitted. I am ready to deposit 50%, Lordship.
Then
This appeal
it will be done, my lord.
under section 173 of the Motor Vehicle Act 1988 is directed against the judgment and award dated 11/10/2023 passed by the learned member Motor Accident Claim Tribunal Bhuburi in MSA case number 242 of 2017. It is to be noted here that by impugned judgment and award dated 11/10/2023, the learned member MSCT Dhuburi has directed the appellant to pay a sum of rupees 66,71,120 being the compensation to the respondent. To the respondents. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and award dated so and so. Admit. No, this appeal is admitted for hearing, subject to depositing 50% of the awarded amount before the registry of this court within a period of 1 week from today.
Lordship, 4 weeks. Lordship, 1
Sorry.
week. Lordship,
2 weeks, at best 2 weeks,
Lordship.
within a period of 2 weeks from today. And liberty is also given to the respondents to withdraw the same from the registry by filing an application.
Deeply, my lord.
Lordship,
Recessal call for the record from the learned member MSCT Dhuri. List the matter after 4 weeks.
Lordship, I have a question. Lordship, I file a I for state. The state may be granted as we are depositing money in Lordship.
So you deposit the 50%, thereafter we'll
Lordship.
consider. The IA will be considered on depositing 50% of the amount before the registry of this court.
Number 12.
May it please your lordship. So this is statutory appeal filed under section 173 of the NB Act, lordship. Lordship, on the last occasion, lordship had asked me to produce one judgment regarding recent negligence, lordship. Because 2 vehicles were involved in the accident, lordship.
So what was the issue on last occasion?
Lordship, because 2 vehicles coming from opposite direction collided head-on, lordship. So my argument, my submission was that there was contributory negligence on the part of the driver of the other vehicle. So on that aspect, lordship had asked me to produce one judgment. Lordship may kindly see para 12 of the judgment, lordship. The highlighted portion, lordship.
So merely because there was head-on collision
Yes,
between
lordship.
2 vehicles would
Similar
amount
facts,
to
Similar fact, lordship.
Hmm?
Fact is similar.
no, how it has to be decided?
Lordship, the highlighted portion I may read, lordship. The highlighted portion, para 12. It was head-on collision in which both the vehicles were damaged, and unfortunately, Rajkumar Dugar died on the spot. The MSCT, in our view, has rightly observed that had it been the knocking on one side of the car, the negligence or rashness could have been only fastened or attributable to the driver of the bus. But when the vehicles had a head-on collision, the drivers of both the vehicles should be held responsible to have contributed equally to the accident. The finding on this issue is a finding of fact, and we do not find any cogent and convincing reason to disagree with the well-reasoned order of the MSCT on this point. Now, lordship, the lordship may kindly see facts of this present case, which is reflected in the judgment, lordship. Lordship may
So
kindly see-
whether you have pointed this issue before the
Yes,
member?
lordship. Yes, lordship.
Where?
This is reflected in page number 17. Page number 17, lordship, and paragraph 13. In fact, the person who was riding the other vehicle was not having any driving license. On that aspect also, defense was adduced by us. Both were motorcycle, lordship.
So Sarset is submitted
Against us. Against us.
then
But there was no eyewitness examined by the claimant side to show that our vehicle veered to the wrong side of the road and that's the other vehicle. There is simply an aberrament, lordship. Lordship may kindly see page 13.
okay. Third, Mr.
T. Kolkata, lordship.
Learned counsel for the appellant. This appeal under Section 173 of the Motor Vehicle Act 1988 is directed against the judgment and order dated 38/4/2024 passed by the learned member MSCT Nagaon in MSC case number 127 of 2022. Is to be noted here that by the impugn judgment and award dated so and so, the learned member MSCT Nagaon has directed the directed the appellant to pay a sum of rupees 1 crore 1,07,696 rupees being the compensation to the respondent opposite parties. No, to the respondents in this appeal. Peruse the memo of appeal and the grounds mentioned therein. And also peruse the impugned judgment and award dated so and so. This appeal is admitted for hearing, subject to depositing 50% of the awarded amount before the registry of this court within a period of 2 weeks.
Lordship, on that respect, I have a prayer, Lordship, because the amount is very big and it has to come section of the head office, Lordship, from Chennai, Lordship. So 3 weeks or 3 weeks, Lordship. would
Okay,
be
3 weeks, within a
3
period of 3 weeks from today. On depositing of the aforesaid amount before the registry of this court, the respondent will have the liberty to withdraw the same by filing an application. Press shall call for the record from the learned member MSCT Nagaon. Please the matter after 4 weeks.
Lordship, one I is there for stay.
So this will be considered only after depositing the amount.
Lordship.
Number 47 for bail hearings.
None appears for the accused on call, or rest is the matter after 1 week. Obliged.
Number 13.
None appears for the yes.
Lordship, here in this matter, your conducting counsel, Mr. Ms. P. Bhattacharya is not well, so he is not in the court. Kindly matter may pass over day, your Lordship. Is it item 13?
1-3.
Oh, yes, yes, 1.
Heard, Mr.
UB Sharma.
Learned counsel for the appellant, and Mr.
T. Gogoi.
Learned counsel for the respondent. On the pair being made by learned counsel for the respondent, the case adjourned for the day.
Item 14.
Yes, item may be lifted after 1 week, Lordship. If
1 week.
1 week.
Okay, 1 week.
Hello.
Rest is the matter after 1 week.
I think the regular second appeal, my lord. I have formulated some substantial question. It is at page 78, my lord.
Substantial question of law at page number
78.
Have you not incorporated this substantial question of law in the appeal?
No, page number 78 is here.
78 is not a part of the appeal memo. Have you mentioned it in the memo of appeal? Not mentioned.
Yes. It is not mentioned. Actually, it is a part of appeal, my lord. And separately, I have not shown, my lord. But
No, have you mentioned it in the appeal itself? Memo of appeal, not mentioned. So there is a requirement of section, subsection 3 or 4 like that.
But what happens, my lord, we always find this substantial question of along with the appeal, my lord, in this way, my lord.
So subsection 3, section 100.
An appeal under the section, the memorandum of appeal shall precisely state the substantial question of law involved in the appeal. So I filed this, my lord, along with the appeal, my lord.
No, no, that is not the spirit of the provision.
My lord.
You have to amend the this appeal memo.
I made it,
1 week.
my lord. In the memorandum of appeal, my lord, I have mentioned this grounds, my lord.
Where? Which part?
My lord. Counts number 4, my lord. For the appeal ought to have been disposed of before disposing of the petition filed by the appellant under order 41/27 Code of Civil Procedure, but no any order is passed in said petition as such the impute judgment and decree is not tenable in law, my lord. It is stated in the ground, my lord.
No,
And
no, no,
fine.
no. You have to mention the grounds specifically in the memo of appeal in view of this subsection 3 to section 100. Heard Mr. D.C.C. Fukun, learned counsel for the appellant. Mr. Fukun submits that he may be granted 1 week time to file amended memo of appeal. Peer is accordingly allowed. Recessal is the matter after 1 week.
All right. Item 15.
May I please? My lord, page 8 is a substantial question, my lord. My lord, I was directed to, my lord, submit additional substantial question. My lord, substantial question 2 and 3 are much important. My lord.
Have you incorporated it in your memo of appeal?
My lord, in the ground, these are stated.
Where?
And my lord, these are also, my lord, part of the memo of the appeal.
Pardon?
Part of the memo of appeal, my lord. Page 8 is also part of the memo.
No, going by subsection 3 to section 100, can it be said that the requirement is fulfilled?
It should be part of memo of appeal.
Yes, then?
My lord, so my lord, substantial question, we, my lord, used to, my lord, include the last page of the part of the memo of the appeal, my lord. Accordingly, I have, my lord, included in the last, in the memo, at page 8. Well, this appeal is, my lord, against the reversal, my lord. Learned Munshi, my
That's
lord.
all right, but you have not incorporated the substantial question of law in the memo of appeal.
My lord, what I am submitting, my lord, this page 8, substantial question is also part of memo, my lord. So, my
No,
lord.
no. You have enclosed that document with the memo of appeal.
Document, my lord, document judgment, the court below, my lord. And my lord, plain WS, all this, my lord.
Hmm. You file amended amended memo of appeal, incorporating this substantial question of law. On the pair being made by Mr. S. Sohan, learned counsel for the appellant, recessal list the matter after 1 week so as to enable Mr. Sohan to file amended memo of appeal. In terms of section 3, subsection 3 to section 100 of the CPC.
Item 16.
Please, madam. On page 9, I have given the substantial question of law. Page 9 of the amendment. The first question, madam, main question. On a substantial question of law. The point first, madam.
Here also you have not mentioned.
But it is part of the appeal. madam.
Where?
Page 9,
Which
madam.
part you have mentioned it?
Page 9.
Page?
Page 9, madam.
No, this is a separate sheet you have enclosed here. Enclosed with the memo of appeal.
This is part of the appeal, madam.
Hmm?
After grounds, this is naturally given, madam.
Hmm?
The memo of appeal, thereafter the certificate is given.
Is it a part of the memo of appeal?
I submit this
Hmm?
is part of the memo of appeal because the.
No, it is a loose sheet enclosed with the memo of appeal. You examine the matter. We'll take up after some time or day after tomorrow.
After tomorrow.
On the pair being made by Mr. Pine, learned counsel for the appellant, recessal is the matter on
14.
Oh, listen.
At no 17 matters for orders. 17.
None appears for the appellant on call, recessal is the matter after 1 week.
Item 18.
Also, we have taken steps for service of notice on respondent number 3 by just 8 and 9. 889 by usual process as well as registered post. Same as not return. 8 appeared.
I'm appearing on behalf of respondent number 8, your lordship, and we also have filed at affidavit in opposition.
There is no provision of filing affidavit in opposition in appeal. Lordship. We have to file cross objection or other thing. There is no provision of filing affidavit in opposition in appeal.
Your Lordship, I am appearing on behalf of respondent number 1 to 7. All the claimants responded.
Wait service report on respondent number 9. Lordship.
So we have to await, or you want to take a fresh step?
Recently, you have taken steps. Lordship.
Recently.
Recently. As per order of the
Heard Mr. S.K. Goswami, learned counsel for the appellant. Then Mr. Mondal
1
for
to 7.
the respondent number 1 to 7, and Madam Deka
And
for 8.
8, your lordship.
for respondent number 8. Office note dated 8/8/2024 indicates that service report in respect of respondent number 9 is still awaited. So rest is the matter after 2 weeks, awaiting service report upon respondent number 9.
Oblige.
Oblige, Your Lordship.
Item number 20.
None appears for the applicant on call. Rest is the matter after 1 week.
21.
Please, your lordship. Lordship, here the appellant has expired on 26/5/19, and the appellant has no child. As such, the appeal has abated. It can be closed.
Applicant expired.
Yes, the appellant expired, leaving behind no children, no legal heirs.
So then we have to close the matter.
My lord, earlier I was appearing for the respondent in this case, my lord. But since long time, I don't have any contact with the respondent, my lord. You are respondent.
Heard Miss
B. Rai.
learned counsel for the applicant. This is IA.
Lordship, in the appeal, we are for the respondent.
This IA is listed for order today.
In the IA, we are the applicant.
Sitola Chaudhary is
In the IA, we are the
died.
applicant. Yes.
Sitola Chaudhary died.
In the main appeal, she is the appellant.
And also heard Mrs. Gayon, learned counsel for the respondent. The learned counsel for the applicant submits that the applicant stroke appellant suffered demise, leaving no legal heirs. In view of above, this IA and appeal stands closed.
Much obliged.
22.
Thanks, Your Lordship. Actually, there is a lapse on our part to take steps, Lordship. I will be allowed to take steps. By tomorrow, I will take steps, Lordship.
Tomorrow.
Lordship.
Tomorrow you will take a step.
Lordship. Actually, it is under preparation to take steps on today's itself, Lordship. But it will be completed on tomorrow.
Mr. Ocon, learned counsel for the appellant, submits that he will take step upon the respondent within 2 working days from today.
Lordship.
Step be taken by registered post with AD and also by usual process within a week from today.
Lordship.
List the matter after 2 weeks or 4 weeks.
Lordship.
4 weeks.
Obliged, Lord.
Probably about 2 years a day.
23 and 24.
পিয়নকেইটা লগাই দিবচোন আগবেলাতে আৰু ৰাতিপুৱাতে লগাই দিব
Your Lordship, my lord, we have filed two testamentary appeals. That is testamentary appeal number 4 and 3 and 4. But due to bona fide mistake, there should be 5 respondents. But last respondent number 5 was omitted due to bona fide mistake. His name was not mentioned in the appeal. So we have filed an IA, that is 299623. And we have also taken steps in time. That is, steps have been taken on 9/5/24 and 10/5/24. So today, my lord, that IA should be taken up, and my prayer is that it should be allowed because they are the parties since the inception. But at the time of filing appeal before this Honorable High Court, the respondent number 5's name, that is Samiruddin, his name was off listed, off. So his name may be implicated as one of the respondents, as respondent number 5 in the testament, both the testamentary appeals, and thereafter appeal may be heard on merit.
Yes, you are for respondents.
My lord, they have implemented respondent number 5 newly. So in that case, my lord, I will have to take instruction whether I have the authority to appear on behalf of respondent number 5. It appears the trial court, he was a party, but
Yes.
they did not implicate.
That is one of our mistake.
So therefore, your lordship, one thing can be done. Let it come after 2 weeks. In the meantime, we shall take the instruction.
Oh, why 2 weeks? So you can obtain instruction within a week.
That can be done.
Yes,
This,
heard Mr. M. Mamun,
This
learned
submission
counsel for
was
the
made
applicant,
by learned friend last time
and
also.
Mr. S. Dotto, learned senior counsel assisted by Mr.
As the
Learned counsel for the respondent number 1 to 4.
Yes, 1 to 4.
Mr. Dotto, the learned senior counsel for the respondent number 1 to 4 submits that he has to obtain instruction as to whether he can appear on behalf of respondent number 5 or not, and as such, prays for listing the matter after a week so as to enable him to obtain necessary instruction. There is accordingly allowed, rest is list the matter after 1 week.
Obliged.
25.
That, Lordship, can you say that?
Date.
Well, because my lord, one problem is this. This is a long pending probate case. If the attested witnesses out of 3, 2 has already died, only 1 is living.
Okay, suggest that date then,
Friday if possible,
next Friday,
this Friday or
this Friday.
out of 3 attested witnesses, 2 have already died. Only 1 is alive, so I am praying for a short date.
All right, my lord, any day convenient to your lordship.
Because it is a matter of telephoning discussion only, nothing.
So on Friday then?
Yes.
High level.
Right.
High level.
Come, right.
Obliged.
16. 25.
May I please your lordship? Actually, I am appearing on behalf of the petitioner. Lordship, kindly go to the office note dated 24/7/24. Lordship, service is already completed.
Heard, Mr. Your good name?
FDA.
Learned counsel for the petitioner.
Lordship, interim order already passed earlier. Interim order already passed earlier. Kindly fix it for admission, Lordship.
Order of Lawazim McCourt dated 24/7/2024 indicates that the respondent refused to receive notice. In view of above, the notice deemed to be served upon the sole respondent. Recessal is the matter for admission hearing. After a week,
After 2 weeks.
2 weeks, okay.
26.
Lordship, service is complete on discord number 1, my lord, and we have challenged only quantum, my lord. That so, my lord, respond number 2 is not necessary party, so he may be struck off from the list. And LCR received, my lord. Let the matter may be fixed for hearing.
Heard, Miss
L. Sharma.
Learned Counsel for the appellant. Office note dated 31/7/2024 indicates that unserved notice issued to the respondent number 2 returned with a report. Addressee always absent, returned to sender. The Learned Counsel for the appellant submits that the respondent number 2 is not a necessary party, and as such, his name may be struck out from the array of the appeal. Petition is or pair is accordingly allowed. The name of respondent number 2 be strike out. Who is for respondent number 1?
A.R. Agarwal.
None appears for the respondent number 1. Recessal is the matter after 1 week for admission hearing.
My lord, already admitted, I think, my lord. This
Pardon?
is for ready for a hearing, my lord.
Oh, already admitted. Okay.
Yes, already admitted, my
The
lord.
Learned Counsel for the appellant submits that the matter is ready for hearing, and accordingly it is provided that recessal is the matter for hearing in usual course.
Oblige me.
Number 28.
I'm appearing for the respondent number 1, 2, and 3.
Respondent number
1, 2, and 3.
none appears for the petitioner on call. However, Mr. Gupta, Learned Counsel for the respondent number 1, 2, and 3 present. List the matter after 1 week.
Okay.
29.
This is your lordship. Lordship, this is a delay petition. The service is complete, lordship. The delay is of 1,277 days. Because, lordship, the delay occurred, lordship, because there was a review petition filed. And if we take from the review judgment of the review petition, lordship, then there is delay of only 57 days.
40?
57
days,
because the though the judgment was passed on 11/11/2016 itself, then the review petition was filed. Review petition, the order was passed on 6/6/22. So that time we get lordship, and then this appeal was filed on 3/8/2022. I mentioned these in paragraph 3 to 8, lordship.
Yes, you are for respondent.
Lordship, I am for respondent number 6, insurance complaint, Lordship.
Any objection?
I have no objection.
You have no objection.
Yes, I have the objection. I am for the claim in mind. My lord, lordship will find it's not correct, my lord, whatever it has been said.
No, review petition was pending before the court of before the tribunal.
Yes.
When?
Since, my lord, yes, the judgment was passed in 2016, my lord. 11/11/2016, my lord. And they filed the review petition's miss case number 18/2019, about more than 2 years. And that has been remained unexplained, my lord.
There must
It
be
has
some
not been
petition, otherwise
because the review was not dismissed because of delay, Lordship. No, I have annexed the order of the review petition. It is at
Lordship-
page 25 and it's a.
No.
So,
You complete, then
no, because you are making a submission
no.
that I have
Let me complete.
misled the court, Lordship. That's a
No,
grave allegation. That's why I'm making it clear, Lordship, in between.
No.
I have not made any misleading here before the court.
No, no,
Lordship.
no, no.
Otherwise, he can continue.
Madam,
I
since when the petition, no, the matter was pending before the review court?
Lordship, this, what I have annexed, Lordship, Miss Case 18 of 19, Lordship, maybe there was a delay conversion. That's why we, Lordship, let the LCR come. Then it will be clear. Maybe there was a delay petition. I do not have that in my file, Lordship. Because otherwise the delay petition, naturally the court will not admit the review petition, Lordship, if it was filed with delay. And in this review petition, Lordship, it was not dismissed because of delay. It was not. It was dismissed because the court relied upon section, this thing that under Order 47 Rule 1 CPC, as per that only.
Yes, Mr. Secretary, what is your objection?
Now, first thing, my lord, Lordship will find their this IA, my lord. Para 3, my lord. Their IA, my lord, para 3, my lord. That though the judgment was passed on 11/11/2016, the appellant company had filed one petition on number 2199/18 under section so and so 114 Redwood so and so, which was numbered as Miss Case 18/2019 for revision of the judgment. Now, Lordship will find again another para 5 minute. That para 4 had order dated 6/6/2022. The review petition was dismissed by the learned member. Now that though the order in Miss Case number 18 was passed on 6/6/22, but the applicant company had knowledge regarding the passing of the order only on 26/2022, but the dealing counsel had not provided the certified copy of the order 6/6/22. He was asked to provide the same. Dealing counsel applied the certified copy on so and so, and it was delivered on 11/7/22. That in the meantime, legal opinion from so and so counsel was sought, which was provided on so and so. That on receipt of the certified copy of the order 6/6/22, file was put up before the competent authority on 18/7/22 for filing appeal. The approval was given on the same day. My lord, now Lordship will, and they have stated in para 8 that thereafter the file was prepared and handed over to the chamber 22/7/22 for preparing appeal. The council took a few days to prepare the appeal, and the appeal was ready and would be filed on 3/8/22. I don't know, my lord, could be filed after receipt of the check of statutory deposit, my lord. Now, Lordship will find the Miss Case order, my lord. Lordship will find at page 25, my lord, of their IA, my lord. This is the order now they are challenging. They are saying that the petition 6/6/2022, the Miss Case number 18/2019, arising out of MSC case number 147/12. The petitioner orientation so and so, heard both sides so and so, while under section, it has been stated in the petition that the instant Miss Case has arisen out of the judgment dated 11/11/16, passed in connection with the MSC case number 1/12. The petitioner contends that the driving license of the driver of the offending vehicle was fake, but the judgment was passed against the petitioner insurance company with a direction to satisfy the award. As such, the petitioner prays for review of the judgment dated 11/11/2016, so that the petitioner can escape from the liability. Order so and so. Relevant portion C, the D, the C last parameter. In the case in hand, we find that the judgment was passed, Lordship has found it. way back on 11/11/16.
Mr. Secretary,
Yeah.
this is not an appeal against that order.
No, I'm not saying, my lord. Only,
Hmm.
only lordship kindly have a look, my lord.
So no, but you are not disputing that the review petition was pending before the trial court, before the learned
disputing.
member.
I'm not disputing that has been disposed of. But thing is this, my lord, when they have come before
No,
this
no,
honorable
if
court,
we exclude that period in view of section 14 of the Limitation Act, how much delay will be there?
my lord, since for about my lord
57 days?
more, no, yes, it may be, but here, my lord, that part from 16 to 19, this 19, that part has remained unexplained, my lord.
Which part?
From 16 to the judgment was offered, judgment was passed in 2016, and they have filed the miss case.
No, in the meantime, that review petition was pending.
No, review petition, my lord, review petition was filed.
No, that period has to be excluded.
My lord, review petition was filed after 2 years, my lord. Review petition was filed after 2 years. It is in 19, 16, 17, 18, and 19, it was registered. Where it has not been explained, my lord.
No, we will not see that period.
No, since
After disposal of the review petition, is there any delay?
my lord, that part also in the even in my lord, when this honorable court has said, even for 35 day, only 25 delays, my lord, which was remain unexplained, this honorable court division bench, my lord, in one case dismissed the appeal, my lord, on a limitation ground, my lord. It was remain unexplained.
No, I am not asking you what division bench or what court has stated in which petition. My question is whether this delay of 57 days is explained here or not.
No, that has not been explained. It has not been explained. It has not been explained, my lord. That part also I have stated in my affidavit, my lord. My objection, lordship, kindly have a look at page 28, lordship. That is para 7 of my objection, my lord.
Yes.
That with regard to the statement made in para 5 of the petition, the answering the opposite party respond number 1 does not admit anything which are contrary to and or inconsistent with in the effect. Though the miscase number 18/2019 was filed by the insurance company after about 2 years of passing the judgment, and thereby the miscase was dismissed by the order dated 6/6/2022. Thereafter, no such proper and good ground have been cited for the period from 26/2022 to 31/2023 for the delay in filing the appeal. Now only they want to say since it was filed on 30th of January 2023. So totally 220 days.
After dismissal of the review petition?
Yes.
220
days.
Okay.
So
yes,
that
madam.
part has not been explained, madam.
Okay.
From 26/2022 to 31/2023.
From who is that?
This is from it would be from 2020, 20th of June, madam.
of
June
2000
2022
till
till 30th of January 2023.
okay. Yes, madam, is there any explanation for this?
Why we are mentioning 31/23, we filed the appeal in 3/8/22 itself. But we will look at the appeal. The delay is also calculated by the registry there itself. But
When you have filed the appeal?
3/8/22.
2022. And when the review petition was dismissed?
6/6/20. 6/6/20.
2022.
From 6/6.
6/6.
6/6 to 6/7 lordship 30 days. From 6/7 to 6/8 it comes to 30 days, but we file on third lordship, so I deducted 3 days, it comes to 57.
57 days.
There is no sufficient explanation regarding all this
This
event for
submission
57 days.
that it was filed on in 23 is not correct. The paragraph.
Okay, okay, we will examine the matter.
Yes, sir.
Heard Ms. R.D. Mazumdar, learned counsel for the applicant, and Mr. Secretary, learned counsel for the respondent number.
I am for the here respondent number 1 minute.
One? One.
Yes.
And
I am for respondent number 6.
3.
6.
6.
But
Argument concluded, order reserved.
Lordship, I would like to submit this for judgment, Lordship.
Okay.
I will also submit.
Yes. Okay.
Item number 30.
My lord, the office note dated. My lord, 8/8/2024 shows that the service is complete.
Heard Mr. S. Dutta, learned counsel for the applicant, learned senior counsel assisted by Mr. S. Dutta, learned counsel for the applicant. Mr. Dutta, referring to office note dated 8/8/2024 submits that as per order of the Lawazima Court dated 7/8/2024, notice upon respondent number 1 Roman 1 to 1 Roman 5 deemed to be completed. And deemed to be served. And as the service is completed. And so there is 1,829 days delay.
Well, there is delay. In fact, there is not so much of delay because we could come to know the death of respondent number 1 in a belated stage. Well, we could come to know when the case was pending here. From the registry, we came to know that this person expired. Then after that, my lord, we filed that application. So that way the delay is because from the date of filing the revision petition, it becomes 1,800 and something.
Okay, will I take up the matter and next week?
Yes, that's convenient to your lordship.
Recess shall list the matter on next Wednesday.
21st.
Wednesday. In the meantime, recess shall also put up an up-to-date office note as to whether any counsel for the respondents, opposite parties, file any kalatnama.
33.
Lord, can you lordship fix it on 23rd?
Yes, okay, 23rd.
Obliged.
23rd is holiday.
Sorry. Then, my lord,
27.
yes,
Item 33.
Delay of 16 days in filing connected appeal in title suit, which will become divorce number 79 of 2019 stands allowed. In view of order passed in this IA, now the registry will proceed to register the appeal and list the same before the court.
Item 35.
much obliged.
Wait, please, Your Lordship. Lordship, there is a delay of 33 days, Lordship, in filing the appeal, matrimonial appeal, Lordship. This has come for the first time, Lordship. Notice may be issued.
Oh, will issue notice that is necessary. Third miss,
P. Borwell.
learned counsel for the applicant. This application under section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 36 days in preferring. In preferring an appeal
Yes, Lordship.
against the judgment and decree dated 22/12/2008 passed in TS Wittenbergen matrimonial number 68 of 2020. By the learned additional district judge number 2, Wittenberg at FTC at Tinsukia. Let notice be issued returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. List after 4 weeks.
36.
May I please, Your Lordship? Lordship, as per office note dated 8/8/24, service complete upon respondent number 1, 3, and 4, Lordship. And await service report upon respondent number 2, Lordship.
Respondent number
2. No AD card, no answer notice has been received, Lordship.
heard Mr.
P. Sharma.
Learned counsel for the appellant. Office note dated 8/8/2024 indicates that service report in respect of respondent number 2 is still awaited. So you want to take fresh is there?
AD card is not received, Lordship. So
Yes,
may
we'll await.
await, Lordship.
Okay, rest is the matter after 1 week or 2 week?
Week, Lordship.
1 week.
2 weeks.
2 weeks. 2 weeks. Awaiting service report upon respondent number 2.
Lordship, there is IA, Lordship. There is stay, Lordship. Interim order is there.
Okay, let the service complete, thereafter we'll consider the
No, Lordship, last occasion there is interim order is along with arbitration appeal, Lordship. IA order is second order, Lordship.
Main case में आए
IA.
की order इसलिए कुछ
I don't order one.
IA order is along with arbitration appeal memo, Lordship. That with arbitration appeal, Lordship.
I orders.
Okay, interim order passed earlier cell containing. I don't know. I had ordered it.
37.
May I please, your lordship, we have filed a IA lordship for stay vacant. Because lordship, this honorable court stayed the decree of divorce against the
38. Come this way.
Regarding item 29, my lord, what I have stated, my lord, that was correctly stated because 31/2023, it was recorded in the registration and date of filing, my lord. That correctly it was stated in the date of filing and the registration, my lord. So that part has not been explained. I have just informed to the honorable.
38.
May I please, Lordship, kindly peruse the office note dated 37/2024, my lord. Service is complete on respondent 1, 2, 3, and 4, my lord. 1, 2, and 3 received by his wife, my lord. Gautam Munda, my lord. Gautam, respondent 1 is Gautam Munda. And received by his wife, my lord. So service is complete, my lord.
So hard means
My lord, there is a delay of only 94 days, my lord. So delay may be condoned, my lord. We have already explained
P.
in four
Hosuri,
para-
learned counsel for the applicant.
We have already
Office
explained.
note dated 8/8/2024 indicates that no advocate has filed any galatnama so far. Though notices were served upon the respondents in view of office note dated 38/7/2024.
Delay is explained, my lord, on para 4, 5, 6, and 7, my lord.
So what is the ground?
I do already explained in para 4, 5, 6, and 7, my lord.
That's all right. You have explained in your petition, but what is the ground?
My lord, it is public sector undertakings, my lord. So routing the, my lord.
The same
paper-
principle is applicable in case of individual and also in this government department
Yes,
or
my lord.
any other public sector undertaking.
Yes, my lord.
So on account of that, you cannot get any premium.
Routing the papers, my lord, from office to office, my lord.
Is that a ground?
Judgment passed on 13/10 to 2023, my lord. And provided opinion with letter, my lord, on 26/10/2023, my lord. From Tezpur, my lord. To the divisional manager, my lord. And in para 6, my lord.
Okay, this application under section 5 of the Limitation Act and second proviso to section 173(1) of the MB Act is preferred. For condonation of delay of 95 days in preferring
94
connected 90.
4 days, my lord.
Have you gone through your application?
Yes. $94 days, my lord.
90?
4 days.
4 days.
Yes,
Then correct it, this
95 days. madam.
application. On the pair being made by Ms. So-and-so, recessal is the matter after 1 week. So as to enable the learned council to amend the cost typing.
Oh, bless me, Lord.
39.
My lord, this is also my lord, service is complete, my lord. And there is limitation is barred by only 82 days, my lord.
I am for respondent 1, my lord. There is no explanation when they apply certificate COVID, my lord. No statement is there, my lord, in the application. After passing the judgment, my lord.
Have you filed any objection here?
Written objection not filed, but they have not.
You want to file objection?
Let them find, my lord. Let them
Okay. Heard Ms. So learned counsel for the applicant and Mr. You.
Sir Ahmed.
Sir Ahmed, learned counsel for the respondent number
1.
1.
2 weeks time, my lord.
Mr. Ahmed submits that he may be granted 2 weeks time to file objection in this application. Care is accordingly allowed. This is a matter after 1 week.
Bless me.
Item 40. Item 40.
I'm happy for respondent number 2. I would like to file objection.
You will file.
I would like to file objection. Objection.
You have filed or you
I
will
would
file?
like to file. Like to file. Also, I point on one thing. This matter will not. They file.
Okay, you file objection then.
Because against the session court order, they file this matter appeal. So they should file criminal petition, not matter appeal. Because 105 CRPC against that they have filed a revision petition. After that, they file this matter appeal. So in my view, this revision, this matter appeal is not maintainable.
Your Lordship, we have at first filed a revision petition. Then the registry called us and told us that a revision cannot be maintainable against the revision. Then we went for criminal petition. We asked their suggestions, but they had suggested us to file a matter.
Okay, let him file objection. Heard Miss, your good name?
As Jed Hayat.
Learned counsel for the applicant and Mr. Gogoi, learned counsel for the respondent. Mr. Gogoi submits that he will file objection in this application. And price for granting him 2 weeks or 1 week?
3 weeks.
2 weeks.
2 weeks.
So as to enable him to file objection in this application.
41.
Fair is allowed.
Applies.
May I please, your lordship?
Yes.
Lordship, in this case, in the connected appeal, when the appeal was admitted, 30% of the awarded amount was deposited before the registry of this court. In terms of the order passed in IA 727/2021. And this IA is for seeking withdrawal of the said amount by the claimant's applicant.
Yes, Mr. Sarji.
Lordship, we have objection, we have filed our objection. We have already filed our objection, Lordship.
Here.
Here, Lordship.
What objection?
Lordship, our appeal is mainly on the ground of that the claimant was a gratuitous passenger. Gratuitous passenger in the vehicle. It was a mini truck, goods carrying mini truck, and he was a gratuitous passenger at the time of the accident. So it is a settled law. In case of gratuitous passenger, the insurance.
Okay, on executing a bond, he will take the amount.
Lordship, Lordship,
What is this?
Owner is the only person who is liable to pay payment of in case of gratuitous passenger.
Okay, later on we'll see. We'll see.
Your Lordship,
We'll pass order for recovery if necessary.
Lordship, once it is released to the claimant, so it will be very difficult for us to recover the amount. Lordship.
Pardon?
Once the amount is released to the claimant, Lordship.
Then what purpose will be served by directing to deposit this 30%? This is only a paperwork.
No, Lordship, at the time of the
Sorry.
the claimant was present.
Heard
For the
Mr.
claimant was
Mondal,
present,
learned
Lordship,
counsel for
and the owner
the
is also present.
applicant, and also heard Mr.
Lordship.
Asarji, learned counsel for the insurance for the respondent. opposite party.
Your lordship can rely on this judgment also about release, because here
Not
it says the
necessary.
execution of money degrees, remedies, restitution is always available, so there is no.
Learned counsel for the, no, this application is preferred by the applicant. 7 applicants. For allowing them to withdraw. No, for directing the registry of this court to release 30% of the awarded amount deposited by the appellant in compliance of the order of this court dated 6/9/2021 in IA within bracket C 7/27 of 2021 arising out of MSC appeal number 80 of 2021 in favor of the applicant along with the accrued interest on the deposit amount. Mr. Mandal, learned counsel for the applicant, submits that when the order was passed,
6/9/21.
while admitting appeal against the judgment and award passed by the learned member MSCT of who is
Borpeta.
MSCT Borpeta
In MSC case number
in MSC
130.
case number 80 of 2021.
No, your lordship, MSC case number 138, 2019.
Where you have mentioned it?
Paragraph number 1.
In MSC case number 138 of 2019, this court was pleased to direct the respondent to deposit 30% of the awarded amount before the registry of this court. And pursuant to the said order, the respondent,
Your lordship,
opposite party had deposited
appellant responded. Appellant opposite party, sorry. They are the appellant.
we are the-
Appellant opposite party.
yes, appellant opposite party had deposited 30% of the awarded amount. That is, what was the amount?
Amount was 580,080. 5,80,080.
5,80,000
80.
80 rupees with the registry of this court. And this application is preferred for according now for directing the registry to release the aforesaid amount to the applicants of this case. On the other hand, per contra, Mr. Asarzi, learned counsel for the respondent, has opposed the petition on the ground that the deceased was a gratuitous passenger in a mini truck, which was not authorized to carry any passenger, and that once the amount is released, it would be difficult to recover in the event of allowing the appeal preferred by the appellant opposite party. But having heard the submission of learned advocates of both sides, I have carefully gone through the petition and the documents placed on the record, and also gone through the order of this court dated 6/9/2021 passed in I within bracket C 7/27 of 2021. But having considered all the facts and circumstances and also the submission of learned advocates of both the parties, as well as behind the as well as the object behind enacting the benevolent legislation, this court is inclined to allow this petition. On furnishing a bond of equal amount, the amount deposited with the registry of this court shall be released in favor of the applicant in terms of above this IS disclosure.
Highly obliged.
42.
May I please, Your Lordship? Lordship, on the last occasion, Your Lordship had directed the matter to be relisted. We have taken justice service upon the sole respondent, Your Lordship. And an affidavit to that effect has already been filed. And however, till date, no one has made any appearance. We completed the justice on 25/7/24, Your Lordship. And our affidavit has been filed to that effect, stating the fact of the justice being taken on 25/7/24 on the sole respondent. Yes. Para 3 of our affidavit, page 24. And the annexure at page 26 is the notice that justice notice is there, where the signature of the sole respondent, Pradeep Kumar Das, is reflected at the bottom. Proprietor.
But Mr. A. Biswas, learned counsel for the applicant. Office note dated 8/8/2024 indicates that no advocate entered appearance by filing any wakalatnama on behalf of the sole respondent. Mr. Biswas, learned counsel for the applicant, referring to paragraph number 3 of the affidavit filed by him, and also referring to annexure what is this? Annexure P.
Yes, sir.
Annexure P enclosed at page number 26 of the petition. In the application, submits that the respondent has received the notice by putting his signature and date, and in spite of service of notice, the respondent chooses not to contest this application. Mr. Biswas, in which paragraph you have explained the delay?
There is 357 days delay, Your Lordship. And I have explained the facts with regard to the same. If your Lordship may kindly, because the judgment and decree was passed on 10/4/23, Your Lordship. And if your Lordship comes to annexure A in the limited IA 2072, your Lordship, annexure A at page 18. By this letter, the chief engineer had asked the executive engineer to take the necessary steps with regard to the judgment which was passed, Your Lordship. On 7/7/23, immediately 3 months after the judgment was pronounced. Thereafter, annexure B, Your Lordship may kindly see page 19. Here, it is a letter dated 10/7/23 in response to the chief engineer's letter by the executive engineer, who is also one of the applicants up here, Your Lordship. Here at the bottom, Your Lordship will find, however, an appeal will be made in the Honorable Guwahati High Court. So the government leader such and such, it is for, by this, we were intimated that he had initiated steps to file the appeal before the Honorable High Court, Your Lordship. However, thereafter, there was no follow-up because as it was assured, then suddenly our process server appeared in the office and asked for the attachment. And accordingly, immediately on that day, by annexure B1, annexure C, page 21, we again wrote to the executive engineer asking as to what is the status of the appeal which you had referred to in your earlier letter, that is annexure B, Your Lordship. Now, in response to that, we on 6/7/24, he apprises us because at that point of time, a new executive engineer has joined. The earlier had retired. Or had
No,
retired.
before the trial court, you have been represented by the government pleader.
Yes.
So government pleader had not informed you about the outcome of the proceeding.
No, Your Lordship. That is the point. We came to know about that and we immediately.
No, your counsel, you have been duly represented by your counsel.
Counsel
The
was
government
there, but
pleader.
no, with regard to the appeal, we became aware and we asked for taking the necessary steps. And the executive engineer informed that he had already instructed the government leader to file the appeal, which is
No, you come to para number 3.
of our.
Yes.
Yes, Your Lordship. Our stand is that we were not made immediately aware about that.
Who is responsible for the same?
Because the government leader did not inform us with that. But it was on 10/4, we immediately asked the executive engineer to take the necessary steps, Your Lordship. And thereafter, the executive engineer informed that he had directed the government leader to file an appeal, which is reflected in annexure B, Your Lordship. And on the basis of which.
So judgment was passed on 10/4/2023.
And
you have written the letter on 7/7/2023.
Yes, Your Lordship.
So
Because
in
we were
between
not
what
aware of
happened?
that. We came to know when this particular copy was served upon us, Your Lordship. And thereafter, we had asked our executive engineer to take the necessary steps. On 7/7/23. And on 10/7/23, he apprised us that he has already instructed the government leader to file an appeal.
For more than 2 months, you slept over the matter.
We had 90 days, I think, Your Lordship, at that point of time, because it would have been before the High Court. Within the 90
Okay,
days.
well, I hear you. Not today.
Because, Your Lordship, the matter is being pursued in the execution case and the government money, because the award, we have a good case before Your Lordship, if Your Lordship.
Maybe.
And because of this.
Maybe, but there is a delay. On
Delay,
your
Your
part,
Lordship, because.
and same has not been explained properly.
Because we had
Can you
explained.
face the
because this is-
music then?
The officers were there, Your Lordship, and we had placed on record the
This
correspondence.
is the
that
matter
was-
for further consideration on when? Next week.
On 2020. Item 43.
Let's do that.
Lordship, in this case, he has filed an application for vacation of the stay order. Madam. So I may be allowed 2 weeks time to file objection, madam. I'm the petitioner.
Heard Mr. A. Dosit. This is for the first time.
No, my lord, IA for first time.
So IA for the first time.
They filed a revision earlier, my lord, and they obtained stay order and actually fact will is
Heard Mr. A. Dosit, learned counsel for the applicant, and Mr.
J. Oscar, madam.
Oscar, learned counsel for the respondent. This application is preferred by the respondent stroke plaintiff. Plaintiffs to vacate the order dated 3/7/2024 passed by this court in CRP which will get IO number 225 of 2024. Mr. Loskar, learned counsel for the respondent, submits that he may be granted 2 weeks time to file objection. There is accordingly allowed to release the matter after 2 weeks.
Everyone did 23rd of
In main petition, you take down interim order pass earlier shall continue.
Item 48.
Interim continued by. Interim order may be continued.
2 weeks.
Interim order may be continued.
Interim continue. Obliged.
48.
Your lordship, I am for the respondent. We have to do 4 to 7. Every
Right.
day.
Carry on, carry on. May I please your lordship?
Huh?
I am representing Union of India Railway Authority, my lord. Here, an ex parte order was passed by the Kapshar Workman Compensation Board. And there is a penalty award against us, 1,48,000. Though it was whole proceeding was fully covered by the insurance company. My lord,
Fully
breach was
covered by?
contract- Beg your pardon?
Fully covered by?
Covered by insurance company, my lord.
Hmm.
Because of any accident, my lord, one employee was fell down and he died, my lord. The whole project was given to my friend for the complete the construction work. He submitted tender, he got the award, and we have handed over the work. Now, my lord, when there is a death, it is your insurance coverage for all employees. When there is a single person died in the incident, my lord, then my lord, he has filed a case and made the party Union of India, not the manager construction or NF Railway. He is the authority who has handed over the work, my lord. Besides that, my lord, since we did not get the receipt in time, notice in time, my lord, so there was no address to us, only Union of India.
So
and
the matter is ready for hearing.
Yes, your lordship.
Yes, otherwise, but my lord, appeal has been admitted. We have statutory deposit also Union of India has made as per order of the court. My only prayer.
They have deposited only 25%.
Yes.
But as per provision of section 30
Yes.
of WCR, they have to deposit the entire amount.
There is an order from the court. How can I go beyond that? Honorable High Court has given the order, 25%. And moreover, my lord, there was a Bakizat proceeding against us, Union of India. And when you got
Okay,
the
okay,
Bakizat,
we will hear and dispose of the matter then.
yes, ma'am, when you got the Bakizat notice, then only you came to
but
know that
not
there was a
today.
case. Yeah,
Not
what?
today, suggested that.
Because Union of India is a party, I pray that any early date, my lord, as per your conduct.
Lordship, may I please pray before your lordship, with your due permission, your lordship, I may be permitted to file affidavit in position because.
File?
Because some documents, your lordship, very vital. I had to annex it.
Lordship, they have received the petition for appearance. And thereafter judgment was passed, after passing of the judgment, they have received the copy and now they are denying.
That is why, lordship, I want to bring on record so that the honorable court may apprise that they have received. I had to apply for the certified copy and the next hearing date. Before that, I will file, if your lordship may permit. Otherwise, I have to show it open court. 2 documents.
By way of affidavit?
Yes, your lordship.
Okay. Heard Mr. Biswas, learned counsel for the appellant, and Mr.
M.K. Nath.
M.K. Nath, learned counsel for the respondent number
4567.
4567, and Mr.
And
Learned counsel for the respondent number
1, 2, and
1, 2,
1, 2, and 3.
1 to 10.
1, 2, and 3, lordship.
Acha. It is submitted at the bar that the matter is ready for hearing. Accordingly, it is provided that the SSL is the matter for hearing after 1 week.
Lordship, can it be on 26th or 27th?
29th August.
29th.
August.
29. In the meantime, Mr. Nath may file affidavit, file. No, Mr. Nath, learned counsel for the respondent number said he will file an affidavit, bringing on record some documents. There is accordingly allowed. List the matter on.
29th August.
Hello.
Number 49.
May it pleases your lordship. Your lordship, I am appearing for the petitioners. Kindly peruse the office note dated 9/8/2024. We were directed to take steps and accordingly we took steps. by the office note dated 9/8/2024, it transpires that respondent number 1 and 2 have filed their wakalatnama. Respondent number 3 addressee cannot be located. Respondent number 8 addressee not found. Respondent number 15 insufficient address, and neither AD card or unserved notice received back for respondent 4 to 7, 9 to 13, and 14. In addition to that, a letter has been received from the respondent number 13, which has been kept at flag Y in part 2 of the matter. So therein, respondent number 3 has said that he has no part to play in this appeal. So he has simply, now my submission before the honorable court is that other than respondent number 1 and 2, all other are pro forma respondents. They have neither filed their written statement in the main suit, nor they have contested the miscellaneous appeal before the first appellate court. So my lord can struck off their names. Main contention is between the respondent numbers 1 and 2 and the petitioners. With regard to
Yes, you are for respondent number 1 and 2.
1 and 2, Lordship, and we will file our objection, Lordship.
Okay, heard, Mr.
AI Ahmed.
AI Ahmed, learned counsel for the applicant, and Miss
P. Hajarika on behalf of R. Chaudhary.
R. Chaudhary, learned counsel for the respondent number 1 and 2. Office note dated 9/8/2024 indicates that unserved notice received back in respect of respondent number 3, respondent number 8, respondent number 15, and neither AD card nor unserved notice in respect of respondent number 4 to 7, 9 to 13, and 14 received. The learned counsel for the applicant submits that except respondent number 1 and 2, the other respondents are pro forma respondents, and they have not filed written statement before the learned trial court. And as such, their name may be struck off from the array of this application. There is accordingly allowed, as shall do the needful in this regard. Learned counsel for the respondent number 1 submits that 1 and 2 submits that she will file objection in this application. Here is accordingly and prays for granting her 1 week time. Here is accordingly allowed, as shall is the matter after 1 week.
Item 50. Deeply obliged.
Your Lordship. Your regular second appeal, my lord, in this, the appeal is admitted and the substantial question of law is also framed, my lord. During the pendency of this appeal, my lord, a money execution case has been filed, my lord. My lord, I have filed an IA, my lord, for stay of suspension of the, my lord, the judgment and the judgment passed by the learned in type money suit and money appeal, my lord.
But the question is,
My lord,
in
not
case of
money execution, my lord.
so you have to deposit the amount before the court, only then we will consider staying the order.
My lord, money, my lord, here, my lord, in the RSA, my lord, on the day of the filing of the RSA, when the matter was heard in land, my lord, when it was admitted and substantial question was formed, a question has been put by the honorable court before. It was true, my lord, it is live proceedings now in this. My lord, that whether any money execution was filed, at that point of time, no money execution was filed, my lord. So it was stated that when the same will be filed, it may be proceeded. We have filed an IA along to stay the judgment and order, my lord. Because, my lord, I have a good case and my lord.
Maybe, but there is a judgment of Supreme Court that this money decree cannot be stayed unless the security is furnished or the amount deposited. And there is provision in the CPC itself. Sub-rule 3 to rule 1 of order 41.
My lord,
Okay, you come prepared. We will consider it on Tuesday or
my lord,
Wednesday.
if my lord can, my lord here, the basic is, my lord, if my lord is, my lord, with regard to service also, my lord, they have denied service, my lord. They have denied with regard to service. If my lord, it fix an early date also for hearing also, and for that also. Because here the issue is with regard to one draft issue.
No, today only this application is listed. The others are not listed today. So it would not be
My lord, the
proper to
LCR
pass any
was also
order.
Not called for. LCR was also not called for. Appeal was admitted, but the LCR was also not called for.
It is correct.
Last registration.
Order to get the listing.
6 weeks serviceable, 5 June, 6 weeks. Fine, sure. 6 weeks, it's serviceable.
Okay. Heard Miss S.G. Borough, learned counsel for the applicant. As prayed for, SSL list the matter along with RSA number 70 of 2024. Or when?
My lord, for hearing, my lord, for, yes, my lord, any.
No, whether service completed in the.
My lord, it is denied, sir.
Has been received. Like X.
After 1 week?
My lord, can a date be given, because my lord, today the matter was fixed before.
19th coming Monday.
Of August.
Item 44, stay matters.
Oblige, my lord.
May I please proceed? Service is completed through district court. But registered post service is not completed. However, respondent himself received the notice issued by the court.
Heard Mr. B. Fokon, learned counsel for the petitioner. Office note dated 8/8/2024 indicates that service upon respondent is completed, and accordingly it is provided that SSL is the matter for admission.
Third September.
After
Date.
date.
3rd September.
Interim order, there is interim order, it may be complete.
Interim order passed earlier shall continue.
46.
Please.
Hmm.
It's a matter of summary suit. Summary suit was filed by the petitioner in the Munsif one. And thereupon, certain substantial questions of law has arisen because it had gone ex parte, and then there was an ex parte vacation petition. And thereafter, there was we had filed a review petition which was rejected, and hence we are here. So they have, I believe.
So service completed.
We have
Service-
filed our appeal.
Objection.
We have filed.
They have filed their objection, but it might not be in the records. We have received a copy.
You have received a copy. Okay, list after 1 week then.
It may be.
Heard Miss Mrs. A. Soikia, learned counsel for the petitioner, and Mr.
S.B. Prasad.
S.B.
Prasad.
Prasad, learned counsel for the respondent.
Okay.
Mr. Prasad submits that he has already filed his objection, but it appears that the same is not placed on record. Accordingly, it is provided that SSL is the matter after 1 week, enclosing the affidavit, no, enclosing the objection submitted by the respondent.
My lord, the
on the
interim
record.
order.
Till then, interim order passed earlier shall continue.
Much.